Good morning, everybody. Woo. Is that as loud? Does that sound as loud to you as it does to me? Excellent. Thank you, Francois. Good morning and welcome to the 10th Annual Samuel Dash Conference on Human Rights. I'm Andy Schoenholtz. I direct the Human Rights Institute here at Georgetown Law. I also co-direct the Asylum Clinic on our campus, the Center for Applied Legal Studies, and I'm the Deputy Director of Georgetown's Institute for the Study of International Migration. Today's a really exciting day for us, and I'm delighted you're all able to join us. We'll be spending the next several hours speaking about law and policy issues with very real and tangible human costs. The United Nations High Commissioner for Refugees estimates that last year thousands of migrants died in the Mediterranean seeking to reach Europe. Hundreds of asylum seekers are currently detained in Manus Island, Papua New Guinea, diverted there by Australian authorities after these migrants sought to reach Australia by boat. These situations have received widespread attention by the media and those concerned with the protection of the rights of migrants. These troubling situations show that migrants are willing to risk life and liberty in the process of migration. They risk these consequences for various reasons. In order to find asylum and protection from fundamental human rights abuses, to better their life chances in terms of livelihoods, to reunify with family. The cross-border migration they undertake can also result in prolonged detention based on migrant status alone. Perhaps now more than ever, migration can be extremely dangerous. It's also the case that migrants are woefully underprotected by international human rights law in practice. With international human rights law, while it protects migrants just as that law protects all humans, these protections are often honored, as they say, in the breach. So today we're going to focus on one aspect of international migration policy that is particularly troubling: border externalization. And by this I mean approaches to extraterritorial actions through which a state prevents the arrival of migrants at its legal or territorial borders. So when Australia or the United States interdicts the boats of migrants on the high seas and diverts them to Guantanamo, Christmas Island, or Manus Island, that's border externalization. When the EU's Frontex border agency concludes a readmission agreement to Ukraine to facilitate the deportation of migrants who enter the EU from Ukraine, that's border externalization. Pushing back the borders can be dated back to President Reagan's interdiction of Haitian asylum seekers on the high seas, just outside the territorial waters of Haiti, starting back in 1981 when he assumed the presidency. Other states have learned a great deal from the U.S. since that time, and many have developed a range of migration control approaches that effectively push back the borders. Today we're going to spend some time exploring these and related issues through three different presentations. First, we're going to hear from a group of law students who are part of a research team that this morning released a report as part of the Human Rights Institute's fact-finding project, documenting violations of human rights of migrant children along Mexico's southern border. This will give us one concrete situation to help us consider these issues. I want to note that our fact-finding project is our Institute's major practicum course and one of the best ways that our students can develop as human rights practitioners. It gives them the chance to conceptualize and to lead, and I do mean lead, a major international human rights investigation. At lunch, we will hear from our keynote speaker, Professor Francois Crépeau. I'll have a chance to introduce him in more detail at that time, but in addition to a distinguished record as an academic expert on migration, Francois currently serves as a UN Special Rapporteur on the human rights of migrants. And he will provide the broad normative context and share insights from his work, both as an academic and as the Special Rapporteur. Finally, we'll be joined by several DC-based human rights experts whose work focuses on the human rights of migrants and refugees, and who will explore ways in which the U.S. law, policy, and practice might evolve to better protect the fundamental rights, human rights, and access to humanitarian protection, especially in the Americas. We're delighted to be joined by colleagues from civil society, as well as from the White House National Security Council and the UN High Commissioner for Refugees. And then we will close with a reception at the end of the day. As with all major endeavors, I'd be remiss if I didn't take a moment to publicly thank my team and the Institute's supporters. First, I want to recognize Ian Kissel, Becca Ballas, and Paulette Smith. Ian is the inaugural Dash Muse Fellow, you'll hear from him in a moment, at our institute and an adjunct professor of law at Georgetown. He came to me with the idea of this conference and really built it. Becca is a rising star, first-year JD student, and she contributed significant research to the concept paper that was produced for this conference and to the overall conceptualization of the conference. And Paulette has provided invaluable assistance on logistics, allowing us to be here today and enjoying ourselves, and we're particularly appreciative of her support and commitment to our students. I also want to thank Michelle Brunet and Jennifer Potko in particular. They are experts that many of you know from the Women's Refugee Commission, but they're also adjunct professors with our fact-finding project. With Ian's support, they have led the year-long practicum course for the students in our fact-finding project. Michelle and Jen, I really can't overstate how grateful, Jen for the moment, how grateful we are as an institute to have benefited from your engagement and your dedication to our students. I know I also speak on their behalf when I recognize you for your contribution. Next, I want to recognize Judy and Rachel Dash, the daughters of our much-beloved former colleague, Samuel Dash. Sam taught here for many years and was a fixture on our campus human rights community and the broader human rights community in Washington and globally. He inspired generations of Georgetown lawyers who have pursued the Law Center's mission of doing justice in the world. Sam's dedication to human rights around the globe is the reason we are here today. We continue his legacy at the 10th Annual Dash Human Rights Conference and are so grateful that you can join us again, Rachel and Judy. Finally, I want to recognize Madeline Lacovara, the Vice Chair of Jesuit Refugee Services USA, for her generous support of our work to promote the protection of migrants' rights and develop the next generation of human rights experts and leaders at our institute. Thank you so much, Madeline. So, I'll turn this over to Ian. We have a full set of events today. You'll hear again from me at lunch. Ian?
Thank you, Andy. Andy's provided some background on what we mean by the concept of border externalization. I just want to share a few ideas about how we feel this policy phenomenon impacts and implicates the rights of migrants worldwide. It does so really in two important ways. First, by directing migrant flows to third countries, externalization efforts can actually influence the nature and duration of legal obligations, right? They can push migrants outside of the territorial borders or the jurisdiction of a destination state and prevent legal obligations, important legal obligations, from attaching. And that's key. Second, externalization can influence how and when migrants' rights are impacted during migration. So they can both decrease the availability of some legal protections and increase the likelihood of certain rights violations. They can prevent migrants, as I said, from coming under the jurisdiction of a destination state, but in the context of externalization, they can also implicate the rights obligations of that destination state when the destination state, through assistance or control of the activities of a third country, promotes activities to secure the border, to prevent migration flows that result in rights violations. So that's an important notion of liability in this context and in this discussion of rights. To note that it's not just the states where migrants end up that can be responsible for human rights violations, but also those states where migrants are trying to travel, but who take action through other countries to prevent them from getting there. The second way, as I mentioned, is directly impacting the rights of migrants, right? So migration, of course, can be a very dangerous process and can implicate fundamental rights, including the right to life, the right to assistance and protection for victims, including victims of crime, the rights to legal assistance, to due process. The list really goes on and on. And when migration management and border externalization shifts migrant routes or pushes migrants into situations where they're more at risk of of being victimized, such as by crime, border externalization can impact those rights, and they can make migrants less able to seek the protection of the state in which they're located. Regardless of their location, of course, migrants maintain fundamental human rights. But border externalization can often make apprehension of migrants and detention of migrants more likely. We'll hear more about some of the rights implicated in the context of detention from our first panel, but it's important to note that border externalization implicates these important rights to liberty and that these rights attach to all migrants. Because migrants can often spend significant lengths of time in detention as a result of these practices, it can also implicate migrants' right against ill treatment when conditions of confinement or duration compromise or violate those rights. Finally, it's key to note here, and we'll hear more from this from both of our panels and throughout the day, that in addition to those fundamental rights that all migrants protect, there are groups of migrants that benefit from higher rights protections. Right, and those protections can be triggered by status. For example, child migrants are recognized to have a special status under international law and merit special protection. But those rights can also be triggered by situation during migration or the situation that causes flight. So in the case of refugees, the rights to international protection attach the moment that they leave their country of origin. And these special rights, too, can be implicated in the context of border externalization. Under international human rights and refugee law, migrants who fear mistreatment in their countries of citizenship have a number of key protections, including the right to leave their country and to seek and enjoy asylum, and a protection against refoulement, return to harm. There are a number of different international legal norms that protect protect migrants from return to harm, including refugee protections, protection against torture and ill treatment, and other human rights protections. And perhaps the most troubling aspect of border externalization is the notion that the phenomenon, the increased attention to migration management, might make this return to harm more likely. It might actually cause states to push migrants back to situations where they fear mistreatment without identifying whether they need international protection. So with this just brief introduction to the many ways in which rights are implicated by border externalization and why these issues are so important for us to discuss today, I'll turn it over to my colleague Eileen, who will lead us through the first panel. Thank you.
Thank you, Ian. Thank you all for being here. My name is Eileen Nguyen, and I'm one of the members of the Georgetown Law Human Rights Institute fact-finding team, which this past January traveled to Guatemala and southern Mexico to investigate migrant children's access to international protection and compiled its findings into this report, which we are presenting to you today. The other members of the team are here as well. Our research supervisors are Ian Kissel, Jennifer Podkol, and Michelle Brunet. The other members of the team are, from your left to right, Nick Stefaniak, Andres Echevarria, Odile Leonard, Lindsay Kaiser, Mary Nelson, and Noah Gimbel. So the title of our report is The Cost of Stemming the Tide: How Southern Mexico's Immigration Enforcement Practices Limit Migrant Children's Access to International Protection. The subtitle really captures the focus of our research. At the time when we chose our topic, there had been a significant increase in the number of unaccompanied migrant children apprehended in the US. This was the phenomenon that the US media dubbed the surge. In 2014, there were over 68,000 unaccompanied children apprehended. And this represents a 77% increase over the previous year and almost a fourfold increase over the numbers apprehended in 2011. About 3/4 of these children were from one of the 3 countries in Central America, collectively called the Northern Triangle. These countries are Honduras, El Salvador, and Guatemala. So at the time of our research, a lot of work had been done on issues such as detention conditions in Mexican immigration facilities and reasons why the children left. We chose to focus our research on the question of access to international protection because we were concerned that amidst the national and international pressure to stem the tide of migrant children, Mexico's immigration enforcement practices might curtail certain critical rights. This is especially important in light of past research on the reasons why the children were leaving Central America in the first place. While it's true that many of the children had economic reasons for leaving or wanted to be reunited with a family member in the United States or Mexico, research has found that the prevailing force driving the surge was violence. UNHCR last year published a study called Children on the Run. The study found that in over 400 interviews of migrant children from Central America, almost 60% were forcibly displaced because of harms or threats of harms that would indicate a need for international protection. The Northern Triangle countries have 3 out of the top 5 homicide rates in the world, with Honduras taking the lead. Gang violence and recruitment and domestic abuse and other forms of gender-based violence are rampant in these countries. So access to international protection becomes highly relevant in this context, particularly given that the people whose rights would be violated by not having access to international protection are those who are exceptionally poorly positioned and ill-equipped to speak up about any rights violations. They are migrants, they are children, many of them are in a foreign country without their parents, and many are trauma survivors of the, possibly from issues that led them to flee their country in the first place, and also survivors of their migratory journey. So we wanted to document the immigration practices, not just the policies and the procedures on paper, but the actual practices, and assess the extent to which these practices comply with Mexico's obligations arising from international law and its own domestic law. So to give an overview of our research methods, we spent months researching the substantive international law, US law, and Mexican law. We consulted with a broad range of experts in the field. We trained in fact-finding skills and ethics in the process of interviewing vulnerable populations. We also created a research methodology which involved a thorough informed consent process, which is particularly important because our targeted interviewees are children. We had our methodology vetted and approved by Georgetown's Institutional Review Board, also known as the IRB. And in examining Mexico's immigration enforcement practices, we chose to focus on Tapachula in the state of Chiapas in Mexico because it's the southernmost region in Mexico, and it's been the primary route for Central American children leaving Central America and traveling through Mexico. We also went to Guatemala, which shares a border with southern Mexico. We then created interview question sets so that we could systematically gather information on the same issues. We looked at the information that we needed to get in order to answer our research question, which is the extent to which Mexico's immigration enforcement practices comply with its international and national obligations. And then we looked at and targeted to interview these populations that were best positioned to answer these questions. So for instance, we wanted to know the questions that were asked of migrant children who were applying for asylum. And for that, we interviewed not immigration officials, but the migrant children themselves who had applied for asylum. In this way, we were able to obtain firsthand accounts of practices. We used interpreters during the interviews to ensure accuracy, and some of the team members are fluent in Spanish as well. Confidentiality was extremely important to us because of the sensitive nature of the information and the vulnerability of those we interviewed, particularly the migrant children. And so all names of migrants that we use here today are, and in our report, are pseudonyms. So our panelists will present our findings, and then after this, we'll hold a Q&A. So if you have questions about the report, there will be an opportunity to ask the panelists. And if you have questions after this event, you can reach out to us at hrifactfinding2015@gmail.com. So to begin, Nick will give an overview of the U.S. role in the issue. He'll describe in greater detail the surge, which, as I mentioned, was how this issue of Central American migrant children came to public attention in the first place. And he'll describe how the U.S.'s response to the surge supported Mexico's current immigration enforcement practices. And then Andres will give an overview of the Mexican immigration system and law, and introduce some of the basic terminology as well as some of the specific international standards. After that, Odile will cover Mexico's detention of children, the duration of detention, and their transfer to DEEF shelters. And then Lindsay will cover the deterrent effect that detention conditions and length of detention have on children who might otherwise seek asylum or other international protection. And then Mary will cover the screening process for international protection, or the lack of a screening process as we found. And Noah will cover access to information about humanitarian protection. So Nick, let's start.
Okay, thanks, Eileen. Thanks for giving an overview of our research and our research question and the methodology of our research. Eileen told you guys all very broadly about the issues that we identified and why they're important. I'm going to take a step back and describe a little bit about how we identified these issues by explaining the broader context of the U.S. response to the surge in unaccompanied minors at the southwest border last summer, and the U.S. response to that surge, and specifically focusing on the U.S. increased support for interdiction of migrant children in southern Mexico, and how the Mexican government has been ramping up its immigration enforcement since last summer. Last summer, in response to the increase that Eileen talked to you guys about, President Obama ordered urgent and aggressive action from the Department of Homeland Security and other agencies involved in immigration enforcement in the United States in order to stem the tide or stem the flow of migrants and families reaching the southwest border. And ultimately, the numbers did decrease from summer to fall, although it's unclear whether or not enforcement measures led to the decrease over the summer or the fall, or whether or not it was just a cyclical decline. But recently, however, the Department of Homeland Security has released statistics that show from October of 2014 to February of 2015, they apprehended 42% fewer unaccompanied minors at the southwest U.S. border compared to the previous year's October to February 5-month time period. In September, as the number of unaccompanied minors starting to decrease, Secretary of the Department of Homeland Security, Jay Johnson, credited a number of U.S. policy initiatives for the decline. Among them, domestically, he credited things like increased border security, faster removal times, the reimplementation of family-based detention, and enforcement against smuggling networks. Extraterritorially, he credited radio ads that the United States has been playing in Guatemala, El Salvador, and Honduras that are telling parents not to send their kids to the United States and telling children and migrants generally how dangerous the trip can be. He also noted that he was pleased that the Mexican government has itself been taking a number of steps to interdict the flow of illegal migrants from Central America bound for the United States. Now, these interdiction efforts in southern Mexico have been successful. From March to September of last year, as the United States was experiencing a surge in unaccompanied minors, the Mexican government was deporting children and migrants at an increased rate. as the U.S. has been recently experiencing a relative decline. Statistics released by the Mexican government indicate that over the final quarter of 2014, from October to December, the Mexican immigration officials deported 67% more children than it had the previous year. So in January, President Obama actually thanked Mexican President Peña Nieto by saying, "I very much appreciate Mexico's efforts in addressing the unaccompanied children who we saw spiking during the summer. In part because of strong efforts by Mexico, including at its southern border, we've seen those numbers reduced back to much more manageable levels." Now, this increased immigration enforcement in southern Mexico is not coincidental and not without U.S. support. For the past several years, the United States has been providing support for Mexico to fortify its historically porous border with Guatemala and Belize. From 2009 to 2013, through the Merida Initiative, which is meant to strengthen the rule of law and increase law enforcement capabilities in Mexico that respect human rights, the U.S. has funded to the tune of about $112 million funding for non-intrusive scanning equipment, improvement of infrastructure, and training of immigration enforcement officials. The U.S. has also donated things like helicopters, night vision equipment, and patrol boats and money for building facilities. And the Department of Homeland Security and the Department of Defense have been involved in training immigration officials and troops that patrol the border. And the funding seems as though it's going to continue. In June, the Department of State asked for $86.6 million more for scanning equipment and increased communication technologies. Congress has funded that Merida Initiative for higher levels in 2015. And out of the $1 billion that you may have heard about that the administration is pledging for support for Guatemala and El Salvador and Honduras, about $300 million of that is earmarked for security issues, which includes more border security. This support and funding has actually translated into action in Mexico. In last summer, Mexican President Enrique Peña Nieto announced a new southern border plan, the Plan Frontera Sur, which aims to secure Mexico's southern border with Guatemala and Belize through a three-tiered security operation that operates within 100 miles of the southern border. While the Mexican government has indicated that the Plan Frontera Sur is aimed at protecting migrants' rights and preventing migrants from taking the dangerous journey northward, the specific details of the plan have not been released to the public, and statistics released by the National Institute of Immigration reveal that the plan has resulted in increases in the numbers of apprehensions, deportations, and detentions of migrants in Mexico. In 2014, the Mexican government statistics reveal that it deported over 107,000 migrants, 97% of whom were from Guatemala, Honduras, or El Salvador. And that figure represents a 35% increase over the previous year and more than 100% increase over 2010. The increase in immigration enforcement has heavily affected children as well. Statistics reveal that over 18,000 children were deported in 2014 compared to about 8,000 the previous year. And over 23,000 children were detained, up from about 9,000 in 2013. Some of the ways they've been increasingly enforcing immigration has been through sending more special troops down to southern Mexico and increasing raids on buses and trains, and increasing the amount of checkpoints, including mobile checkpoints, to enforce immigration. Recently, immigration officials boasted of raiding the trains in southern Mexico 153 times last year. As Eileen explained, the report entitled Children on the Run, released by UNHCR last year, that identified international protection needs in 6 out of 10 unaccompanied children in the United States. UNHCR actually released a report based on 200 interviews of children in Mexico in late last year, called Arrancados de Raíz. It was based on 200 interviews of children either apprehended or traveling through Mexico. And in that report, UNHCR found that about 48% of the children told stories that indicated they had international protection needs. And when their asylum rights were explained to them, about 28% of these children indicated an interest in applying for asylum in Mexico. So in short, since last summer, since the surge in unaccompanied minors at the southwest U.S. border, the Mexican government has increased its immigration enforcement at its southern border. And that's a little bit of the background about why we thought it was important to study children's access to international protection in southern Mexico. Before we get to our findings, I'm going to pass it over to Andres, who's going to explain a little bit more about the Mexican immigration system.
Thank you, Nick, for providing the international legal context to these issues. I will now introduce Mexico's immigration law system and the main agencies that are in charge of its enforcement. The first thing that I will say about this system is that as we started researching this framework, we realized that on paper, Mexico's immigration and refugee laws are thorough, protective, and human rights oriented, and provided, in fact, adequate safeguards to migrants in general and vulnerable populations of migrants, such as children in particular. However, through our research, we found there to be significant disparities between what the law dictates and the actual current practices executed by Mexican authorities. As it will be explained throughout this presentation, we found that in the treatment of migrants, Mexico does not fully comply with a number of fundamental obligations established both in international laws and Mexico's own domestic laws. Until 2011, immigration and asylum in Mexico were governed by a set of unsystematic, disengaged provisions, which became more and more inadequate as immigration reality grew more complex in the country. In 2011, Mexico enacted its Immigration Act and Regulations and Refugee Act and Regulations. These laws were a remarkable improvement in Mexico's efforts to regulate migration and international protection, as they provided a more systematic and comprehensive legal framework, and also a human rights protection element to these subjects. Migrants who are found to be unlawfully present in Mexico may be apprehended by either the federal police or the National Migration Institute, or INM. INM is the primary immigration enforcement agency in Mexico. It administers all immigration proceedings, including border control, domestic control, admissions, apprehension, detention, deportation, and repatriation of migrants. If the apprehended migrant is a non-accompanied child, then the law requires the participation of child protection officers, or OPs. OPs are INM immigration agents who are supposed to be specifically and adequately trained in child protection and focus their task on that subject. The law establishes a number of obligations for OPs in the treatment of children. They must first carry out an interview when children are apprehended or in detention. They must make a best interest determination, which is a key step in the process which migrant children navigate through seeking asylum or other immigration status in Mexico. They must also screen children for international protection needs, and they have the positive duty to inform children of their rights in a manner that is appropriate for their age, and in general, any human rights that they have, and in particular, their rights to seek international protection. As my colleagues will explain in detail in a minute, our findings show that there's a number of issues surrounding OPs. First, it is reported that their training is insufficient. Also, INM is not sufficiently staffed with OPs to face the child migration that is currently taking place. Also, OPs do not fully comply with all of the legal duties that I just mentioned. Some of them are fulfilled inadequately, and other duties, such as the case of best interest determination, are not carried out at all. We didn't found any evidence in Mexico that any procedure for the best interest determination of a child is carried out by OPs or any other Mexican official. When an irregular migrant child is apprehended, he or she will be placed in detention. That is what the law dictates. And detention takes place at one of the immigration stations, which are distributed throughout Mexico and run by INM. And they will stay in detention until their immigration status is resolved. In the case of unaccompanied child, they must be immediately transferred to shelters in the run by the National System for Family Development, that is DIF. So unaccompanied child are to be by law transferred immediately from the stations to these shelters. And in the case of accompanied children, they must stay in detention at the immigration stations along with their family members. So in short, all migrant children stay in detention. The difference is that those at the immigration stations are in a detention facility meant for adults and accompanied children, and those who are at the DIF shelters are in a more child-friendly environment with a network of social workers and sometimes psychologists, but they are deprived of their liberty nonetheless because they are confined to these shelters. They cannot leave and not even to attend school. If in the context of immigration detention, a child either expresses a will to seek asylum or is identified by OPs to be in need of international protection through one of the interviews that I just mentioned they must carry out, then INM must refer the case directly to the Mexican Commission of Refugee Aid, or COMAR. COMAR is the asylum agency, is an independent agency under the scope of the Ministry of Interior. They are in charge of adjudicating all asylum and complementary protection cases in Mexico. We found that COMAR's capacity is limited. They only have 3 offices in Mexico, and there's also little information on asylum adjudication. They only publish very basic statistics that you may find on their website. The main international protection mechanisms in Mexico, in place in Mexico today, available to migrants are refugee status and other forms of complementary protection. Refugee status is granted to those who meet the definition of refugee as established in the Refugee Act. And this is individuals who, due to a well-founded fear of persecution on account of nationality, race, religion, political opinion, membership of a particular social group, and in the case of Mexico also gender is one of the grounds, are outside of their country of nationality or permanent residence and unwilling due to that fear or unable to seek protection from this country. And also meeting the definition of refugee is, as Mexico is a member of the Cartagena Declaration, this extends the definition of refugees to those who are fleeing their countries because their life or liberties are at risk due to situations of generalized violence, external or internal conflict, systematic human rights violations, or any other circumstance that affects the public order. Once a person is recognized as a refugee, they get, of course, non-refoulement rights. They cannot be returned to the country where they expressed and are to be found to have a well-founded fear of persecution. They get, in Mexico, a permanent resident status with their refugee recognition, and this means they can obtain work permission and also family reunification rights. Besides refugee protection, refugee status, The other form of international protection in Mexico is complementary protection. Mexico has the humanitarian visa. This visa is offered to those who are eligible for this visa are migrants who are victims of a crime in Mexico or a witness of a crime in Mexico. Unaccompanied children are also by being an unaccompanied child eligible for the humanitarian visa. And asylum applicants who are waiting for a pending application of asylum are also eligible for the humanitarian visa. The humanitarian visa provides a lawful status of 1 year, and it is renewable for equal periods by the discretion of the INM. As I mentioned before, migrants stay in detention while their immigration status is being decided upon administratively, and this includes asylum seekers who place a defensive claim of asylum when they are in detention. Asylum in Mexico must be filed within 30 days of entry to the country, and the procedure by law takes 45 business days for the original petition to be decided upon by Comar. That is approximately 3 months. And if the applicant chooses to appeal that petition to Comar, there's an appeal procedure that the same agency that decided the first that issued the first decision will revise the case, and that is another 45 days on appeal. So any given applicant is looking at least 3 months in detention. The many who are denied the first petition and appeal to Comar are looking at 6 months in detention in the conditions that I explained before. And if they choose to pursue the judicial review, which is an additional review that is not done by Comar as the previous one, but by the judiciary, then the law practically allows for indefinite detention of the person until the claim is resolved. We found that detention in these conditions operates as a deterrence to seeking asylum in Mexico. And on that note, I will pass now the floor to my colleague Odile, who will elaborate on detention as it takes place in Mexico today.
Thank you, Andres, for this useful description of the Mexican immigration system. We're going to keep the chart up so you can keep referring to it during the rest of the presentation, and you can also find it on page 23 of the report for those who can read it. So like Andres said, if migrant children are apprehended in Mexico, they are automatically detained in migration station. The most famous one in Chiapas is called Siglo XXI, and it's one of the biggest detention facilities in the Americas. It can hold up more than 900 detainees, and migrant children are detained together with adults. I'm only going to focus on the detention of children, asylum seekers, both for unaccompanied children and accompanied children. But first, I need to make a few points. So like Andres said, unaccompanied children benefit from special protections in the law due to their particular vulnerability. As soon as a migrant is determined to be an unaccompanied child, a special agent of INM, the OP, must conduct a best interest interview and, among other things, explain to the child why he is being detained and proposes alternatives to detention. It is also required by law that unaccompanied migrant children are transferred to federal, state, or local social service agency, known as DIF. The only exception to that rule is that there's no space in DIF facilities or in private shelters. Indeed, there are a lot of private shelters along the route of migrants, the most famous one being the Casa de Migrantes Calabrini. In that respect, the law respects the obligation under Article 37 of the CRC, the Convention on the Right of the Child, to detain children for the shortest period and under the least restrictive conditions. And indeed, DIF is considered as an alternative to detention in Mexican law. And conditions are better in DIF than in Siglo XXI, as Lindsay will soon explain. But according to our findings, DIF still constitutes detention. Children are deprived of liberty. When we visited the DIF facilities, there were fences all around. They couldn't leave. They received very few visits, most of them from government agencies or NGOs, and they could not attend schools. I think among the children we interviewed, Martin, who was 13 years old, really captured the feeling shared by so many migrants. He described his detention in DIF as saying, "I'm stuck here with nothing to do. I get desperate sometimes and I want to escape." So I'm going to cover the duration of detention, the transfer to DIF, and I'm going to cover briefly the detention of accompanied children as well. So migrant children who seek asylum in Mexico are detained for excessive periods of time, first in immigration stations such as Siglo XXI, and subsequently in DIF facilities. In Siglo, they spend considerable period of time between apprehension and the transfer to DIF when transfer actually occurs. Mario was told by INM that he couldn't apply for asylum before 30 days, which, as Andres said, was wrong because you only have 30 days to apply for asylum. So he waited 30 days, he applied on the last day, and then he spent the entire pendency period of his claim in Siglo, which is 45 more days, just to get a denial of his claim. The shortest period of detention among the children interviewed was 27 days. Fray Matias published a study. It is one of the main NGO actors in Chiapas who represents migrants in their asylum claims. And they reported that in 2013, 6,700 children were detained in Siglo. And many of them were unaccompanied children who spent more than a month there. In DIF, children spend even longer stretches of time. Ricardo was 17, spent 10 months as he exhausted all the appeal processes of his asylum claim. Jacobo and Eduardo had been detained in DIF for about 6 months when we spoke to them. In that regard, it is similar for accompanied children or family units, as they spend considerable amount of time, both in Siglo, between 2 and 3 months, and at least 3 more months in DIF facilities. One of the examples was Martin's family, who had been denied asylum twice. When we interviewed him, he was 1 month into a 6-month judicial review, and had already been detained in DIF for 7 months. They're going to spend almost a year in DIF at least. Obviously, these lengths do not constitute the shortest period of time required by international law. Let's talk about transfer to DIF now. Like I said, it is mandated by Article 37 of the CRC as well as Mexican law. And the only way it doesn't occur is that there's no space available. But it is our findings that it actually is only open to asylum seekers and extremely vulnerable women and girls, mostly pregnant women and girls. So it is not an issue of capacity. When we were there in the beginning of January, DIF facilities were not running at full capacity. However, when we interviewed consular officials, they told us that Siglo was replete with children, that indeed the day before they had sent a bus back with 18 children back to Guatemala, a fact which was confirmed to us by Guatemalan officials in reception centers, such as Nuestras Raíces. So the transfer to DIF works as the exception rather than the rule. Most children stay in Siglo from apprehension to return to their home country without ever being transferred to DIF, if they don't apply for asylum nor are flagged for international protection. This failure to transfer is unlawful and constitutes arbitrary detention, as children are detained unlawfully for long and unpredictable time periods and are not detained under the least restrictive means necessary. These 2 prongs have been reiterated by the Special Rapporteur in reference to Article 37 of the CRC. These detention practices also contravene the principle that states should always consider the best interests of the child as a primary consideration when they take decisions affecting children. Finally, the detention of accompanied migrant children. Accompanied migrant children do not benefit from any particular provision in the law. They are subject to ad hoc decisions. However, they are still subject of international law, and in particular, the principle of family unity. And family separation occurs in Siglo, as adult males are held in one section, women children under 12 and girls are held in another, and boys between 12 and 17 years old are held in the youth section. The contacts between family members are very scarce, happen under supervision in hallways or in common areas. If they are transferred to DIF, the adult males are not allowed in DIF, and they remain in Siglo. And then the contacts become completely inexistent. Matteo told us he hadn't seen his father in 2 months since he had been transferred to DIF. This separation, not in the best interest of the child, constitutes the violation of the right to family. So our recommendations to the Mexican government regarding the detention of children are the following. Put an end to the detention of all migrant children in Siglo XXI. Eliminate the possibility of prolonged detention of migrant children. Increase the capacity to DIF to expedite transfer of children from immigration stations to appropriate shelters. Allow children to leave DIF to attend school, so at least to constitute a first step toward being a real alternative to detention. The mere fact of detention, in particular due to the length and the conditions, create a deterrent effect on the children to apply for asylum, as Lindsay will now demonstrate.
Thank you, Odile. So in addition to the practice of detention violating the human rights of child migrants in the ways that Odile has just discussed, we also found that detention is acting as a deterrent to the right to seek and enjoy asylum for these children. Odile has given some of the legal framework, so I'm just going to cover the parts that are specific to deterrence. So under the International Covenant on Civil and Political Rights, children cannot be detained solely because the state has made a rule for a broad class of people, including just for migrants. So UNHCR has stated that detention policies aimed at deterrence are generally unlawful under international human rights because they are not based on an individual assessment as to the necessity to detain. Our findings certainly show that there is not an individual assessment occurring in order to detain, since screening and assessments of children are not being completed in a regular fashion, which Mary is going to talk about next. Under international law, detention is only to be used if absolutely necessary and must include an individual assessment that takes into account conditions and duration and the effect of those aspects of detention on children. So we found that these two factors, condition and length, were the most significant in shaping how children perceived detention and therefore sometimes acted as a deterrent to seeking asylum. As to conditions, we were denied access to Siglo, but many of the children we talked with spoke about the conditions at Siglo XXI. 15-year-old Enrique told us, "It's an awful place. People are crammed, it's very hot, the food is terrible, and it's dangerous for us teenagers because they put us together with Maras, or the Central American gang members." Enrique's complaints encompass the most common complaints that we heard from the children. So the first, limited space. Children complained about lots of people being kept in small rooms, and they were not able to leave those rooms except for at designated times. Bad food was the most common complaint that we heard from the kids. They would compare the bad food that they'd had in Siglo to the better food that they were having in DIF. So the presence of gangs was another one. One 13-year-old boy told us that gang members beat him. One mother told us that she had to keep asking immigration authorities at the station to increase the monitoring of the youth section. She had 2 sons who were being kept in the youth section, and when she was able to meet with them during the short family unity times that Odile talked about, they would tell her all these stories of how gangs were beating up on other boys. And so she asked multiple times for increased monitoring. Some children also reported poor treatment by the immigration officials themselves. A 16-year-old boy reported being yelled at and laughed at by INM officials. He said, "They treated us like dogs. We slept on a mat on the cement floor, and whenever we talked back, they would take away the mat and our food." A psychologist who works with child migrants in one of the DIF shelters told us that the effect of conditions in Siglo carry over even when the kids are transferred to DIF, because the kids can expect the conditions of DIF to be like they were in Siglo. So the problem that occurs is that when children are supposed to be making the decision whether to apply for asylum or not, they're still in Siglo because they haven't been transferred yet. So they make the decision based on the experiences that they've had. So based on what they know of the poor conditions of Siglo, they often decide that asylum isn't what they want to pursue. The fear about conditions is then compounded by the length of time children are told that they will have to spend in detention if they seek asylum. So waiting for the adjudication of their asylum decision takes 45 business days, which means at least 2 to 3 months in detention. So the Deaf psychologist explained, very few children request asylum. What scares them is the prospect of being detained for 3 months. We try to tell them the length of the process in days or weeks, because when we say 3 months, it sounds like a long time to them. They don't want to request asylum mostly because of having to wait in detention 3 months. Consular official who regularly visited Siglo XXI and Deaf facilities in Tapachula said that children similarly tell him that the length of detention deters them from seeking asylum. He explained, the problem is that you can explain that people are eligible, but they have to wait 45 days, 3 months. This is a critical time. They have to be locked up for that time. As soon as they hear that, they go back, even risking their life. 15-year-old asylum seeker Paulina believed that other kids don't apply for asylum because they are afraid that they will have to stay here 3 months in detention. Other children expressed their fears about the length of time in terms of idleness and how it meant that they couldn't communicate or see their family. Martin was an asylum seeker in Deaf, and Odile already mentioned him, but his quote bears repeating here as well. He told us, "Here with nothing to do, you get desperate sometimes and you want to escape." Maria, 17, was not seeking asylum and she was waiting to be deported. So when we asked her if she had heard of asylum, she responded, "Yeah, they told me I could apply, but they said it would take 3 months, and I do not want to go that long without talking to my family. If they would let me talk to my family, I might consider applying for refugee status." So our findings led us to the conclusion that the poor conditions of detention, combined with the fact that the children who seek asylum will be deprived of their liberty for a long period of time, together these things effectively deter children from seeking asylum. So based on that conclusion, we make the following recommendations to the Mexican government. 1, the length of detention should only be as long as absolutely necessary to be in compliance with international law. 2, children should be allowed to safely leave Deaf shelters to interact with the larger community and to attend school. 3, Mexico should consider and implement alternatives to detention for migrants so that conditions and length are no longer a deterrent for children when determining whether they should seek asylum. So Mary is now going to talk about the screening process that children are supposed to go through while they are in detention.
Thank you, Lindsay. While Odile and Lindsay just covered issues directly related to the length of detention and detention conditions, Noah and I are going to cover issues related to access to international protection while these children are in detention. Specifically, I will cover the role that screening plays in ensuring that international protection needs are identified for these children. First, I will cover briefly international law. Next, I will give an explanation of our findings. And finally, I will give some facts and figures that help contextualize our findings. Then I'm going to hand it over to Noah, who will cover access children have to information about international protection while in detention. States are not only obligated to protect recognized refugees, but also obligated to screen children for international protection. Under the Convention on the Rights of the Child, whether unaccompanied or accompanied, children must receive appropriate protection and humanitarian assistance. In addition, the best interest should be the primary consideration in any decision related to the child. States must conduct ongoing best interest determinations. These must be in a friendly and safe atmosphere, and according to the recommendations of international standards, state officials should assess a child and be part of a multidisciplinary team of professionals who specialize in child and adolescent development. These assessments and screenings are of the utmost importance because of the state's obligation to non-refoulement. This is the obligation that prohibits states from returning people to their home country when there is a well-founded fear of persecution on account of race, religion, nationality, membership of a particular social group, or political opinion. Of course, these are the standards in the Refugee Convention. Moreover, as Andres mentioned, Mexico is a party to the Cartagena Convention, which also identifies refugees when there is a threat of generalized violence, foreign aggression, internal conflict, and massive violations of human rights. Children have the most expansive protection of non-refoulement. Under the Convention on the Rights of the Child, it would be inappropriate to return a child when there is substantial grounds for believing that there is real and irreparable harm to that child. We found that migrant children who are apprehended in Mexico lack access to international protections. To reiterate what Andres explained, OPIs are the officials explicitly tasked with evaluating children for any international protection needs. Most of the unaccompanied children we spoke with were not screened by OPIs. They did not know what an OPI was. They had no experience with being interviewed for any sort of international protection. For example, the two brothers already mentioned, Jacobo and Eduardo, spent 27 days in Siglo XXI and had not been screened and did not know what an OPI was. The only reason they had been identified as potentially needing international protection was because they asked for asylum. As Noah will point out, this becomes a problem because not all children have information about their asylum or international protection rights. One of the consular officials we spoke with described OPIs as merely an administrative job. They fill out paperwork, but they don't interact with the children. On the other hand, we did speak with one unaccompanied child who spoke with an OPI several times. Mario from Honduras met with an OPI and found him extremely helpful. This only goes to show that OPIs are not inherently useless. When OPIs have regular contact with the children, they can make a difference for these children in identifying their protection needs. Not surprisingly, no accompanied child we spoke with received any assistance from an OPI. The OPIs are not obligated to provide screening for the accompanied children. They are only obligated to help when help is requested. To give some contextualized background to our findings, there is no formal best interest determination procedure. Mexican law dictates that OPIs screen children for international protection needs during a best interest interview for which there is no formal or objective procedure in place. OPIs are not independent agents. These are immigration officers, and they're the only ones tasked with screening these children, which is a stark difference from the recommendation of a multidisciplinary team in international policies. There are only 28 OPIs working in Tapachula. That is, only 6% of all OPIs are located in Chiapas. This is compared with 37% of all children detained for migration reasons being in Chiapas. UNHCR in 2013 found that 80% of children had no knowledge of OPIs. As my colleagues have stated, some of these children are fleeing from extremely violent situations. This is exceptionally concerning because without determining if these children will be returned to a situation of real or irreparable harm, the Mexican government has no way of knowing whether it is complying with its international obligations of non-refoulement. It's concerning that children are not routinely screened for these international protections. Many of the migrants have never met the immigration officer who is responsible for determining if there is any international protection needs. This is why we have recommended to the Mexican government that they ensure sufficient staffing of OPIs across Mexico, and particularly in Tapachula, where many children are located. We recommend the improved training of OPIs to ensure that they can effectively assess children's best interests. We recommend the amendment of screening procedures in place in the immigration regulations, the New Child Welfare Act, to require protection screenings for all children, not just unaccompanied children. And lastly, we recommend the implementation of a formal best interest determination procedure to ensure that the primary consideration in immigration proceedings is in fact the best interest of the child. Now I'm going to pass it on to Noah, who will speak about the information children have while in detention.
Thanks, Mary, and thanks everybody for staying along with us. I hope that we haven't run out of coffee, and that we'll be wrapping it up here and let you get to the questions I'm sure are all burning in your minds. On a heavier note, the duty to inform children of their asylum rights, as Mary mentioned, as a corollary to this obligation to screen children for international protection needs, derives both from the principle of the best interest of the child and the right to seek and enjoy asylum. The Inter-American Court for Human Rights recently issued an advisory opinion on the rights of migrant children traveling in the Americas. In it, they stated, "Children must be provided with all necessary information adapted to their age and maturity on their rights, the services available to them, and the procedures they may assert. In particular," the opinion stated, "they should be informed of their right to request asylum." Mexican law places this duty on the OPIs, who, in addition to their screening duties, they must inform all unaccompanied children of their right to seek and apply for asylum. In the case of accompanied children, because Mexico does not recognize accompanied children as primary asylum claimants, but rather as derivative to their parents' claims, no such obligation is codified in Mexican law. In spite of the obligations to unaccompanied children, we found that they were not being informed of their right to seek asylum in Mexico. As mentioned, most children that we interviewed had never met an OPI. Ricardo, who had spent more than 10 months in detention before finally being granted a humanitarian visa, he cited the lack of information as a main reason why many of the children that he came into contact with throughout the course of his detention chose not to apply for asylum, or rather did not apply for asylum. This lack of knowledge among child migrants was also expressed to us by many civil society actors who deal with large numbers of child migrants in Tapachula. A Tapachula-based lawyer with Fray Matias, which is the main the only human rights organization in Tapachula that represents migrants in their asylum claims, she told us that when the Mexican government does provide information on asylum to migrant children, it's usually given in writing, and then it's written in a legalistic language that most children, especially trauma survivors, are not going to comprehend. The director of the Scalabrinian Shelter for Migrants in Guatemala that receives deportees from Mexico and the United States also told us that the majority of child deportees coming in from Mexico had no idea about their rights to apply for asylum. And finally, this generalized lack of information is corroborated in UNHCR's report from 2014, Arrancados de Raíz, which found that of the children they interviewed, 73% were unaware of the right to apply for asylum in Mexico. So it's interesting that I'm commenting on the lack of information on asylum when the majority of the children who we interviewed were actually asylum seekers. They were being held either in DEEF or in other private shelters as their asylum claims were being adjudicated. So where did they get the information on asylum? Mostly that gap was filled by other migrants, and in some situations it was also filled by some of the NGOs that I've already mentioned. Fray Matias has limited access to the immigration station Siglo XXI. They're limited only to conduct specific client visits. So that means that the detainee must already have established a claim for asylum in order to request that meeting with his or her lawyer. They're not permitted to give general rights presentations inside the detention center. In the DEEF shelters, they do have greater access, but as we've mentioned, most of the people who end up being transferred to the DEEF shelters are already asylum seekers. UNHCR does have broader access to the detention center and is able to conduct more generalized rights trainings and distribute literature on the rights and procedures for asylum in Mexico. However, given the fact that deportations, known as assisted returns of children, unaccompanied children who do not seek asylum from the detention center, happen just so rapidly, those UNHCR presentations are not able to reach all of the children who pass through Mexican immigration. So like I said, most migrants learn from other migrants about the right to seek asylum. Ricardo, as well as the brothers Jacobo and Eduardo that we've mentioned, who were all asylum seekers, learned from other migrants. They were all denied in their initial asylum claims, and they cited a lack of knowledge or incomplete knowledge of the asylum procedures as one of the reasons why they felt that they were denied as they awaited adjudication of their appeals. So similarly, children were not informed of their right to seek complementary protection in the form of a humanitarian visa. The children who did know about the humanitarian visa, this option only became apparent to them after having already been denied at least an initial claim to asylum, and in many cases, an appeal as well. So that means 45 business days pendency of the initial claim, so about 3 months, and then another 3 months, so a total of 6 months in detention before being made aware that they have this option for temporary status in Mexico. In conclusion, Mexico's effective denial of the right to seek asylum to Central American child migrants is a function of several failures on the government's part to meet its international humanitarian obligations. Children are not actively screened for protection needs, which places on them the burden to seek out asylum actively. The fact that they're not informed of their right to seek asylum, nor of the procedures by which their claims will be adjudicated, makes this burden too heavy for most child migrants to bear. As discussed, these children often have already survived trauma, both in their countries of origin from which they may have fled, along their migration journeys, and in detention as well. So the need to implement adequate procedures, both to screen and to inform children of their rights to asylum, is urgently demanded under the principle of the best interest of the child. To the degree that the United States is promoting enhanced Mexican border enforcement, it is also implicated in these violations. The rights of child migrants should not be sacrificed in the name of border security. We recommend that the Mexican government ensure all child migrants apprehended by the Mexican government are informed by child protection officers, OPIs, or by other government agents about their right to seek asylum. We also recommend that the Mexican government allow NGOs regular access to the detention facilities so that they're able to help migrant children, both by providing information on their rights and by offering legal representation and advice to all child migrants. To UNHCR, we recommend an increase in funding and resources to the Southern Mexico Field Office so that it can reach a greater portion of the child migrants who are processed in the immigration station at Siglo XXI. Finally, we recommend that the U.S. government stop encouraging Mexico and Central American countries to interdict migrants in order to prevent them from reaching the U.S. border. Any funding disbursed for the purpose of fortifying borders in Mexico and Central America should be conditioned on the receiving country's consideration of affirmative efforts to protect the rights of migrants, including the right to seek and enjoy asylum or other forms of international protection. We also recommend that the U.S., to the extent that it continues funding immigration enforcement in Mexico, ensure that a substantial portion of those funds go towards screening and identifying migrants with international protection needs, providing alternatives to detention and protecting vulnerable populations. This translates into support for Mexico and Central American countries in their screening efforts, in particular, channeling funds towards increasing the capacity of COMAR, Mexico's refugee agency, to investigate and adjudicate asylum claims, as well as the capacity, the training, and the quantity of the OPIs to screen and inform children of their rights. Thank you.
Thank you, Noah. So to summarize our recommendations, we do recommend that Mexico stop detaining all children in adult detention facilities like Siglo XXI. We recommend that they increase DEEF's capacity so that transfers can be expedited, and that children be allowed to leave DEEF shelters to do things like go to school. We recommend that children be detained only as long as absolutely necessary, and that Mexico consider alternatives to detention so that length of detention and detention conditions are not deterrents to children who would otherwise seek asylum. We recommend that Mexico ensure adequate staffing of OPIs across Mexico, but particularly in Tapachula, and that they improve their training to ensure that OPIs can effectively assess children's best interests. We recommend that that they require protection screening for all children and that they implement a formal best interest determination procedure. And that they ensure child migrants apprehended by Mexican immigration officials are informed of their right to seek international protection. And to help with that, to allow NGOs regular access to detention facilities so that they can help inform children of their rights and offer legal assistance. We also recommend that the UNHCR field office in southern Mexico have increased funding so that it can better reach the child migrants that are processed through Siglo XXI. And finally, we recommend that the U.S. stop encouraging Mexico and Central America to interdict merely to fortify the border, and that it condition its funding to these countries on their compliance with international human rights standards. So at this point, we'll have a Q&A. So if any of you have questions for the panelists.
I'll bring around the mic.
Okay.
I'll let Eileen recognize.
Oh,
First, Bill Freilich with Human Rights Watch. Congratulations on a really excellent report and quite a really thorough presentation. What I wanted to do is delve a little bit deeper. Andre sort of mentioned that, okay, we've got a sort of a normative framework and then we've got a reality that doesn't quite match up. And I'd like to go deeper into that gray area with you to ask about really wholly illegal, unlawful, extra-legal behaviors, extortion, summary removals, corruption, the presence of private actors that may be preying upon people that may be in collusion or ignored by authorities that would also represent a deterrent factor and part of what in effect would prevent people from lodging asylum claims of children in particular. This is a gray area. It doesn't appear that something that you've explicitly taken on. And I know it's a tough area to document, and so it may be that this is more on the order of hearsay, or it may be that you're giving them a clean bill of health in this regard. But I just wanted to get some reaction to you about that whole gray area that you haven't quite addressed at this point.
I can take it. Yes, clearly there is publicly available information about these occurrences, the safety issues that children face throughout this journey, and the involvement of corruption by public officials and the operation of drug cartels. This is only information that has been reported journalistically. It's beyond the scope of our report. We can only speak as observers of that reality, but we cannot come to any conclusions or findings on it. But it is certainly part of the problem that children face when they leave their countries and try to go across Mexico to the United States or go to a certain place in Mexico. And I believe it's not that I believe, it's that the spirit of the law in the creation of OPs and other forces is to try to provide some protection to these children as they go through Mexico and try to prevent them from staying out of the grid and trying to bring them into the system. And in that regard, I think the role of the OPs and other forces, such as there's another task force run by INM that is supposed to help children have a safer journey or come into the grid of the INM and keep them away from being out in the open and being victims of any sorts of awful things that take place in Mexico. If that operates as a deterrence or not, it's not something we can establish, but it's certainly something that does take place.
Thank you. I also want to congratulate you on the report. It's really very well done and very interesting. You weren't allowed to go to detention centers. One of the privileges of my mandate is that when I'm allowed to go to the country, that's where my mandate stops. If I'm not allowed, I can't go. One of the privileges is that if I go to a country, I have the power to request to go anywhere, so I can visit detention centers, and sometimes I visit quite a lot of detention centers. And so there are questions that are not mentioned in your report, and I'd like to hear it in the same way as Bill asked the question. If it's something that you've heard of, or even though it's not really in the reports, it's something that you may comment on. And it's 4 points. 1, guardianship. Is there any provision in the law that unaccompanied children should be provided a guardian? And have you heard of practices, or is it simply, not talked about? Second, age testing. Have you heard of age testing practices to know whether this person is a minor or not, and whether the person should be placed in such and such facility, etc.? Because that's a big issue in many countries. Third, communications with families abroad and generally communications with the outside. Do they have access to telephones? Do they have their cell phones? Do they have, that depends on very often on local practices, but that's very often extremely important to adults and children to be able to phone home and talk to people. And third, you mentioned the role of UNHCR. Have you heard of any role for the International Organization for Migration, especially in assisted returns, for example? Is there something to comment on that?
So to repeat the question is with regard to our siglo of 21 denial. If we had heard of a law providing for guardianship of the children, if there's age testing practices, whether they're migrants or not, if they have communication with the outside, and whether we have any recommendations for the International Organization for Migration.
I can answer about guardianship. The law doesn't establish that the children are under the guardianship of either INM or DIF, and this is an issue that we don't have any findings on, but we observe that there could be some kind of tension as to which agency receives the guardianship, and agencies seem reluctant to take this responsibility. But in strictly legal terms, there is no guardianship exercised by any of these agencies. And one point to research would be whether the consulates should be having a more active role in exercising that guardianship.
I could take the rest of the ones.
Sure.
With regard to age testing, the law does require that the determination be made of whether or not the child is a minor, whether or not the detainee is a minor. However, we don't know anything about how that determination is made. In most cases, they work with the consuls from the countries of origin in order to determine both nationality and age, but obviously there are cases where that's not possible, and we don't know what happens then. Communication with families and with the outside, there is the limited access to telephones, and on sort of the procedures by which that access is provided. We don't have specific findings. However, with respect to Maria is, I believe, the pseudonym of one of the migrants we interviewed, she did mention that the very limited access that she was able to have in terms of communicating with her family was a motivating factor for her to sign off on her assisted return. And as regards the International Organization for Migration, they do have a presence in Tapachula that you can even see on one of the pictures that's in the report. Their logo is there on one of the wall murals. However, their involvement is something that we were not able to produce findings on.
Just to add a little bit onto that, assisted return is actually carried out by the National Migration Institute, and actually OPIs are supposed to accompany children back to their country of origin. On top of all of their other duties, they're also supposed to work with the repatriation of children who are deported from the United States back to Mexico, which might be another reason why they're not doing the jobs that they're supposed to be. But that's how assisted return is basically carried out.
I'm Shana. I'm with the Jesuits of the United States and Canada. I actually wanted to make a comment and also ask a question. One, I'm just like shocked to hear about such a kind of robust role of the consulate, given that we're talking about people who could have refugee claims. And that's obviously something that could imperil the lives of people who are fleeing, not just private actors who are perpetrating persecution, but also state actors who are part of the deeply infiltrated organized crime rings in Central America. But I also wanted to ask you guys about the way in which the manner of detention might degrade the child's ability to trust state authorities in Mexico. You mentioned, I don't remember who mentioned, but you mentioned gang violence in the Siglo XXI facility. You mentioned that guards as well could be verbally or maybe physically abusive to children. What is a child's kind of state of mind by the time they're asked whether they want to seek asylum, if they are asked whether they want to seek asylum?
So the question was as to how the manner of detention affects the child's state of mind and how it might affect their decision to apply or not to apply for asylum.
I can actually take both of those. I'll make a little note on your comment. We did speak with the consuls and asked about that. That's not something we ended up writing about in the report, but they made it very clear that they try to stay out of any asylum claims. The role of the consuls is more, which Noah talked about, is more about determining the status of the children and then helping them in the repatriation process. So they do try to stay out of the asylum process. As to whether the manner of detention, deters children from trusting when they're seeking asylum, we did talk to the psychologist at the DEEF shelter, and a lot of the children had talked to her. But again, those are children who have decided to seek asylum. Because we did not have access to Siglo, we can't speak to what the state of mind of those children is, and why they decide not to seek asylum. Again, because we didn't talk to anybody who, that wasn't a reason that any of the children gave, that they didn't trust who they talked to. But it could be something that further research could look at.
I'm Rachel Dash. Thank you. This was disturbingly illuminating. I just have one question, one thought. The question is, and then I realize it's not within your scope, but I couldn't help, I think, when I heard you talking about the U.S. responsibility for promoting these practices and paying for them, largely, how do these practices there compare with our practices in the United States with children? And the others, one of the things I do is work and teach about trauma with children and adults, not in this situation. And the question of state of mind, when we talk about training, of asking, it's trust, but it's not always, they can't say I don't trust. It's just a whole world view of how dangerous it is to say anything. And, when you were talking about the training of the OPs, it concerns how they would get that information. But anyway, I'm interested in how we compare, and if it's not within your purview, and I'm wasting time,
It's not within our purview, but I think the second panel may cover a little bit more on U.S. practices and those types of things. So, yeah.
I'm Madeline Lacavara. I'd like to ask a question about the end of your chart. Some children are repatriated, some children appeal the asylum decision, and some children apply for a humanitarian visa. If you had 100 children as your ends, how would you say that shook out in terms of what they actually choose to do?
In terms of asylum adjudication, the Mexican Commission on Refugee Aid does not release disaggregated data to show how many children versus how many adults apply for asylum. In the first 8 months of 2014, however, only about 1,700 migrants applied for asylum, which spread out over a whole year would be about 2,400, 2,500 out of 107,000 migrants who were deported. So a very small number of migrants end up applying for asylum or complementary protection. I believe about 300 total migrants received humanitarian visas, and that could be an unaccompanied minor, or it could be someone who is a victim of a crime in Mexico, or it could be for other humanitarian reasons. So while we can't say with specific numbers how many children get asylum or how many get a humanitarian visa, those forms of protection are relatively rarely given out in general with the numbers we have.
And I know you're not making any assumptions, but did it look to you as if what they were really doing were warehousing and sending home? Very unscientific. We can just leave the question.
I can paraphrase. Fray Matias, the human rights organization in Tapachula, has called the Mexican immigration system, I believe, a deportation machine.
Hi, I'm Alaide with the Evangelical Lutheran Church in America, and we actually just went to Central America and did a similar trip. And one of the things that we heard over and over again from both government officials and civil society in the region is that advocating in Mexico is impossible, that they've tried to change some of the things. For example, the OPs are not going all the way down to the repatriation centers in the buses with the children, and there's mixed buses of children and adult males. And I'm wondering if that's something that you also heard, that the Mexican government is not willing to change some of those practices despite governments and civil society bringing it up, if you're aware of that.
So on the issue of the difficulty of advocating in Mexico.
Yeah, I can take it. Yes, we interacted with Fray Matias, which is the main NGO in Tapachula. They referred to a whole host of issues with carrying out their advocacy in all migration issues in Mexico. They told us that they get very limited access to the immigration stations, so it makes any kind of research or accountability efforts very difficult. We were denied access as a academic research team to the immigration station Siglo XXI, any other immigration station in Mexico. We were denied access to any interviews with any immigration officials at the federal level in Mexico and the officials of Comar. So in terms of barriers to advocacy, I would say that's something that takes place when there's limited access to perform research. From where? I'm sorry.
The consular
Oh,
offices.
no. About access? Oh, no. No.
Hi, my name is Jerry Rotenberg. Looking at this politically, prior to the border externalization push by the United States, how many of these children were actually planning to stay in Mexico? It seems to me that you have a system that in Mexico was not really set for this massive numbers that all of a sudden they had to deal with. I mean, do you have any feel for how many of these children actually, prior to this last couple of years, pushed to stay in Mexico?
So on the question of what percentage of these children may be actually intended to stay in Mexico versus continuing to the United States? Go ahead.
So we can't speak to what happened before the surge because we weren't able to do research before then. Our research is limited to now. But in terms of who we talked to at this point, many of the children and the families wanted to stay in Mexico. Now, you have to keep in mind that our research we interviewed children and families who are seeking asylum because, again, we didn't have access to SIGLO.
I would also mention that, in the border region with Guatemala, there are migrants who are just sort of circulating in the area across borders, and that's something that goes back for many years. And now, in some cases, those sort of circular migrants are being caught up into the immigration system.
Hi, I'm Mary DeLaurie with the Jesuit Conference, and I just had a couple of questions to follow up on several areas you mentioned. One of the things we started to hear from several shelters in Tapachula is a difference in treatment of Guatemalan children, in some cases, a number of families being asked to actually come to Tapachula from Guatemala to pick up their kids, rather than they're being returned in a more official way. And also, if you saw or heard any difference between the consulates of the three countries in terms of the services they were providing. There's been a real push from El Salvador, more so with their consular services in the U.S. perhaps than in Mexico, but to have a greater focus on protection than has been the case necessarily for Guatemala or Honduras. If you saw or heard anything that was different there. And just the final issue, in terms of clearly Comar and OPIs and other authorities in Mexico are not fulfilling their mandates or their roles. The larger challenge is in terms of the broader political will or interest to expand asylum options in Mexico writ large. Did you have many conversations as part of your research on that larger concern, that it's not just an accident that some of these services are not being provided? It's a broader concern that we're all facing.
Take the first question on the question of the differential treatment of Guatemalan children and other Central American children. Mary, would you like to jump in?
That wasn't the focus of our research. I think there may have been some murmurs, but we can't really speak to that because that wasn't something that we researched in depth, so we can't come to a conclusion about that. Do you want me to take both questions?
Oh, well, on the question of the consulates in the 3 countries. Someone wanna-
I can talk about the consulates. Again, we only were able to speak to 2. But in terms of even speaking to the migrants that we interviewed, some children were able to say that they had seen their consular officer multiple times, whereas others had not. And I think one migrant even gave us like a ranking of who she thought, were the better consular officers. But again, that's just one person's opinion on that. And again, this wasn't the focus of our report, and we don't make any findings on whether there's a significant difference between the offices.
What about the OPs not fulfilling their roles, and the question of like
Right.
I think that's something that is part of the context and the reality of the situation. That the NGOs that we spoke with sort of told us that the general population is not really engaged with issues of migration in Mexico. It's not as much of a political issue there as it is in the United States, and the United States' stance is pretty clear through some of the statements that Nick quoted. So I think that certainly is. We don't speak to circumventing that or addressing that, but it's just part of the reality.
Hi, I'm Judy Dash. I just wanted to follow up on a question that Jerry Rotenberg mentioned. One was about where the kids in particular want to go. Do they want to stay in Mexico? And I would think they're applying for asylum in Mexico. I mean, that where they want to go, they're not going to say, well, I really want to go to the U.S. But also, did I hear you say that the OPs have a dual role? That they are responsible for repatriating the kids to their country and also receiving and repatriating the ones that are thrown out of the U.S.?
Yeah, yes, OPs.
And how many of them are there?
I have the number. I think we have the total number in the report. There are, in Tapachula, there are, where did it go? 28. But I don't think they're not repatriating the children, they're traveling with the children.
Yeah.
They're supposed to be in Mexico or in the U.S., receive the kids, and go, how can they be in places?
No. They are in charge of instrumenting the repatriation of children. So they deal with the paperwork and are supposed to carry out all these obligations that I mentioned. And regarding, sorry. Yeah, and some agents travel with children during the repatriation. And so your question was regarding the repatriation of immigrants from the U.S. to Mexico?
It's just that it seems like an impossible thing for 28 people, at least there, to be handling what the U.S. supports and needs and demands probably, as opposed to what it's kind of, it seems like it really relates to the surge.
Well, yeah, I think that is why there's so few of them in southern Mexico. Most of them are in North Mexico, taking care of the children that are being returned from the U.S. That is the main problem.
Yeah, I think
It's the same figure that is in charge of all the children in migration, either Mexican children deported from the U.S. or Central American children that are supposed to be returned to their home countries, and that they are supposed to accompany during their travel, but fail to do so. Lisa, that's your question.
Hi, I'm Shaw Drake. I'm a third-year law student here at Georgetown, and was in your shoes last year. So congratulations again on the culmination of what I know is a massive amount of work. My question might also be a bit outside the scope, but I wonder, assuming the hypothetical situation where Mexico did stick to the letter of their law and implemented the recommendations that you're proposing today, is there systems in place to ensure the rights of the child beyond the granting of humanitarian status or asylum status in Mexico? Are there systems there that ensure that children will be placed in appropriate locations throughout the country and have access to all of the services that they need to respect their rights beyond the detention and legal process that gives them that status in the first place?
That's a good question. There are not really those pieces in place. What there is the DEEF system, which is like a social services system that exists in Mexico, both at the federal, the state, and the local level. And it's basically a network of shelters and support for those shelters. So the same that there are DEEF shelters specified for migrant populations in the southern border region, there are other DEEF shelters throughout the country that are dealing with children, like maybe a foster type situation or an orphanage type situation. Also with disabled people, elderly people in Mexico. So it's what exists, but we really can't speak to whether that's adequate or equipped to ensure the long-term rights of children.
Hi, my name is Tabitha King. I'm actually Shaw's colleague from the project last year, so I'm going to join him in congratulating you guys on your huge accomplishment and the contribution that you're making right now. My question has to do with, I noticed that in your recommendations you have mainly focused on comments to the U.S. government or the Mexican government and civil society, but I noticed that you didn't necessarily comment as much to what role the U.S. or civil society or other parts of the advocacy community that could also participate in raising awareness of this issue. And I'm curious why you decided to do that and what your thoughts are. And I asked that question because to me it seems like the reaction in the U.S. in response to the surge and that sort of thing is a lot about deterrence or that it's a good thing that the surge has reduced. And so I'm wondering if there's something about the way that the advocacy community in the U.S. can respond to make sure that there's a full awareness of what is actually happening.
Noah, you want to jump in? I'll take it. While we don't make specific recommendations in the report, a lot of what we're doing right now after the launch of the report is trying to reach out to U.S. advocacy. So, in addition to this report, we have several meetings throughout this week that are more tailored to trying to get a connection with U.S. Organizations to, draw attention to this issue, as well as try and keep our work going after, we all finish with the project.
Just a little bit to jump off on that. We've reached out to a lot of practitioners about this issue, and a lot of the practitioners who know a lot about this issue are actually in the room right now. So one thing we're working on right now is just awareness raising to get more people involved.
Hi, thank you all. Emma Buckout from the Latin America Working Group. Quick question about the comments on DEEF not being at capacity. Was that specifically in the DEEF in Tapachula? And so we've heard from partners in Mexico that there's been a lot of pushback from DEEF about not wanting to accept migrant children at all, since they are sort of the social services institution for the entire country, Mexican children and families as well. So did you hear any of that in your interviews at DEEF? And are there any available stats, I guess, on the capacity issue?
We don't have stats on capacity. I'm sorry. Of DEEF, what In Tapachula, there's two DEEF shelters. There's the state level Chiapas government DEEF, and they're mostly families who are being held there, and a couple of unaccompanied children as well. And then there's the municipal Tapachula local DEEF shelter, and that's specifically equipped for girls, young women, young mothers, especially with babies or small children. And that local DEEF shelter is specifically, it's only about, I think, a year old, or not more than a couple years old. And that's specifically to handle migrants. But as for pushback or anything like that, we don't know.
I might just jump in. Yes, DEEF was not created to take care of migrants. And there is another center, it's a day center that is really supposed to take care of children in the street and provide just really social assistance to all of children, also Mexican children. But the two shelters that Noah mentioned, just too comfortable to welcome only migrants. They didn't have any other populations than migrant children. And when we went at the beginning of the year, they were definitely not running at full capacity.
Hi, I'm Elizabeth Reeser Murphy from the Young Center for Immigrant Children's Rights. And I have two unrelated questions. One, what are the backgrounds of the OPs? Are they law enforcement? And when they are working with the children, are they dressed in uniform? And beyond that, do you think that they should be law enforcement, or should they have backgrounds in social work or law? And then my second question is, how are Mexican officials dealing with the influx, or have they seen an influx of indigenous language speakers, especially from Guatemala? And are the consulates providing services for these children in their first languages rather than Spanish?
I can take the first question.
The first one. Yeah, as regards to the first one, OPs are actually part of the National Institute of Migration. They're technically immigration agents. The training to become an OP, we've heard that it's just not that much training. It could be as much as a weekend course, but generally they are hired from within the Migration Enforcement Institute, which some actors have criticized. For example, UNICEF recommends that OP should actually be part of DEEF, which is specializes in child welfare, which they would be presumably hiring out of an organization that's in charge of child welfare instead of an agency that's in charge of hiring from employees that are immigration enforcement. And as for the second one.
Mary, did you want to jump in on that?
No, that's
okay.
it.
And
the
what about
uniforms.
the second
In addition to the information Nick just gave, they do wear special uniforms. It's a turquoise or a blue color, and it's supposed to say OP on the sleeves. So they're supposed to be easily identifiable by the children.
And as for the indigenous languages, we don't know. We don't have any statistics from the Mexican government on it, nor from the consulates, and we didn't encounter any children without Spanish language proficiency or fluency.
We did hear that in reception centers in Guatemala, they didn't have official translators for like Mayan children, for example.
Ready for round two. Thinking based on a number of the other questions and comments, curious about the voluntariness of return. IOM, for example, is supposed to be a VR, assisted voluntary return. So he's talked about the accompaniment of OP officers for assisted returns. Do they, in statistics or otherwise, make a distinction between voluntary departure and deportations? And does that color sort of what we're looking at in terms of the numbers of people that are involved that are that are opting to quote unquote voluntarily return as an alternative to prolonged detention or otherwise, or do they not make these distinctions? But and again, particularly between IOM, I mean, according to their own constitution, they shouldn't be involved in a deportation, but they may well be involved in something that's categorized somewhat differently. So, how do they? Is there an AVR in addition to an AR, or how does how is this dealt with?
The Mexican law doesn't provide for deportation of minors, period. They're all categorized as assisted return, and that process has at least a formal voluntariness element, whereby the child signs a piece of paper that agrees to the assisted return process. As to the effective voluntariness of that signing off, a lot of for example, the CRC general comments have raised concerns about the ability of children to voluntarily sign off on assisted returns in the context of detention. So that sort of goes into our findings on detention as a deterrent.
Yeah, I will add that the voluntariness element of that return is dependent on the best interest determination, and when our findings show that those are not being carried out, then that puts a question mark on whether these are voluntary returns or just plain deportations and the use of euphemisms in Mexican law.
Okay. That's a great set of questions. Wonderful challenges. But after you've delivered an extraordinary report, I was incredibly impressed with your findings, the professionalism with which you delivered these findings this morning. This has been a really wonderful, robust discussion, and the beginning of the raising the consciousness in this country and globally on these issues that are affecting us so seriously with regards to the children in our region. So first, please join me in thanking this team for wonderful work. And second, we'll be breaking in a moment for lunch. I want to thank all those who've helped prepare the lunch today and delivered it on a timely basis. We will, after everybody has a chance to enjoy lunch, we will then turn to our keynote speaker later this morning, Francois Crépeau. So please help yourselves, and we'll then continue once everybody's had a chance to have some lunch. Thank you. Great job. Special Rapporteur on the Human Rights of Migrants. He is a Fellow of the Royal Society of Canada and was a Fellow from 2008 to 2011 of the Pierre Elliott Trudeau Foundation. The focus of his current research as a scholar includes migration control mechanisms, the rights of foreigners, and the interface between security and migration. His numerous articles and books cover the full range of migration issues, from asylum to security and globalization. He's a member of several editorial committees of leading journals in our field, just to name a few: the International Journal of Refugee Law, the Journal of Refugee Studies, Refugee Law Reader, Droits Fondamentaux. He's clearly sought after by all these leading publications in our field for his advice. Before teaching at McGill, Professor Crépeau was a professor at the Université de Montréal from 2001 to 2008, and holder of the Canada Research Chair in International Migration Law. I'm sure one of the few international migration law chairs that exists actually in the world. I know of only one other, but I'm sure there are a couple, but they're You can count them on your hands, okay? And he was the founding scientific director of the Centre d'études et de recherche internationale de l'Université de Montréal, CERIUM, as it's called. From 1990 to 2001, he was a professor at the Université de Québec en Montréal. So he's been hanging out in Montreal. I think we're getting that message, right? You must like it up there, Francois. Despite the cold. But he's gotten away, so listen to where he's gotten away, as guest professor. The Université Catholique de Louvain, so Louvain, Belgium, right? The Institut International des Droits de l'Homme in Strasbourg, so he's gotten to be in France. Several times, actually. The Graduate Institute for International Studies in Geneva, one of the leading graduate schools on international studies globally. The Institut des Hautes Études Internationales at the University of Paris, and elsewhere. I'm going to stop because the list is really long. So in short, we are very fortunate to have one of the leading international migration experts with us today. And we've asked Professor Crépeau to talk about the international migration normative context and to share insights from the specific work he has done as the UN rapporteur. Without further ado, Professor Crépeau.
Thank you very much, Andy, for this generous introduction. I'd like to start by congratulating the students on the report we've heard about this morning. It's really great work, great investigative work, and doing it while, having all sorts of other courses and in a very short time with a deadline is an achievement in itself. I'd like to thank the organizers, in particular Andy and Ian, for inviting me to share with you a number of ideas which will come from my experience as UN Special Rapporteur on the Human Rights of Migrants. And especially it'll come from the two reports that I've written, one to be presented next June, on the protection of the rights of migrants at the borders of the European Union. And the situation in the Mediterranean. And that's why the Human Rights Council last October asked me to do a second report because of the situation in Italy last summer. And so there are a number of proposals that I make to the EU in those reports, and they serve as the basis for this presentation today. I've just cobbled up a structure of my presentation. It should be on PowerPoint. It's not. It's okay. But you see where the 9 points that I will go through. So my first point is that migration is normal and here to stay, and it'll be irregular if we don't change attitude. Migration is in the DNA of mankind. We all come from the Rift Valley in Africa some 200,000 years ago, and we've conquered the earth 100 times over since then. I mean, this is what we've done always. Border controls date back to the mid-19th century. It's 150 years as compared to 200,000 years. Stopping migration isn't possible over the long term. Diverting it lasts some time until often other countries do the same thing. When needed, migration will happen no matter what. The huge investment of the American authorities on border controls on the Mexican border have not prevented over 69,000 youth from Central America to cross over into the US last summer, at the same time as the Italian Mare Nostrum operation picked up 160,000 people in the Mediterranean last summer as well, despite huge cooperation of the EU with countries of the southern rim of the Mediterranean. So sealing, quotation marks, international borders is impossible, especially in democratic states. Not that any politician is able to utter that truth, but that's what we see out there. Migrants will continue arriving despite all efforts to stop them, often at a terrible cost in lives and in suffering. My second point is that criminalizing immigration has very little deterrent effect, but huge human rights consequences. Irregular migration has been criminalized during the past 3 decades. The language used by politicians and the media is criminalizing. The systematic detention policies are a form of criminalization. Being smuggled into countries is often presented as having participated in a highly criminal activity which taints the migrants themselves. Smuggling and trafficking are systematically associated, and often the expression are used interchangeably, although these are very different activities. This portrayal of migrants has very negative consequences, adding to all the barriers that migrants already face. Irregular migrants will fear speaking up, even when exploited by employers and landlords who know very well that they will not protest or mobilize, unionization being most often unavailable. In many countries, the criminalization of irregular migration is in the discourse and in the practices more than in the law or in policies proper, as migrants are most often dealt with under administrative law, not criminal law. Until recently, administrative law wasn't invasive of individual rights. Now, administrative immigration regulations, proceedings, and policies mimic the criminal justice system in many ways, including the importation of criminal categories, criminal law enforcement mechanisms, institutions of criminal punishment, and crime control rationales. However, the stringent guarantees which evolved over a few centuries in criminal law, for example, on the burden of proof or on the admissibility of evidence, have not reached the core of administrative law, which is why states prefer it to criminal law, as it is a more flexible and efficient tool for managing migration. Yet, in many states that do not have the death penalty and do not extradite towards the death penalty, such as Canada and European states, the administrative judge today is the only judge who can send people to face execution, torture, and arbitrary detention, but without the guarantees. Administrative detention has increased exponentially without effective oversight mechanisms, as we saw, which could address the issues relating to the criteria for detention, duration of detention, and conditions of detention. The idea of detention as a last resort, only if absolutely necessary, is applied almost nowhere, and alternatives to detention haven't been seriously developed in any of the countries I have visited in my mandate. I've also seen children detained in all the countries I've visited so far, even when the UN Committee on the Rights of the Child has made very clear that detention can never, ever be in the best interest of any child, and that unaccompanied minors and families with children should neither be detained nor be separated by reason of their immigration status alone. For children, I've never seen a good guardianship arrangement or adequate best interest determination procedures in any of the countries I've visited, including European countries. Here again, administrative law is failing the test of human rights protection in most countries, and administrative judges aren't empowered and trained to make sure that human rights guarantees are included and implemented in such administrative issues. For example, in 2012, Greece announced Operation Xenos Zeus, in which all apprehended irregular migrants were to be detained, whatever their circumstances, including children and families with children. Not one single European state objected to this manifest violation of international and European human rights law, and the European Commission never discussed bringing an infringement procedure against Greece. Moreover, this criminalization drives all irregular migrants further underground into the hands of smugglers and exploitative employers and landlords. If the host state's objective is effectively to control borders, such criminalization is counterproductive, since it entrenches mobile, creative, tech-savvy smuggling rings, which take over the control of cross-border movements of persons. And externalization creates even more human rights violations. Many countries have attempted or are attempting to externalize border controls, as we saw this morning, i.e. make transit countries bear the brunt of the detection, detention, and deportation of irregular migrants or the processing of asylum claims. There is a political argument, an efficiency argument, and a legal argument against such practices, and I'll go through all three. The political argument is that the only reason that global north states do this is because they have figured out very quickly in the early 90s that in the context of a liberal democracy, arresting, detaining, and deporting migrants is difficult and costly. As lawyers, civil society organizations, judges, faith-based organizations, politicians, national human rights institutions, the media will get in the way and make life difficult, quotation marks, for immigration enforcement, based on a variety of legal and political grounds, such as protection needs, length of stay in the host country, age of arrival, etc., which are all human rights issues. It appears much more efficient to do capacity building in transit states so that their authorities will carry out the arrest, detention, and deportation of irregular migrants and refugee determination procedures if need be. Most of those countries do not have the same democratic culture, the same human rights protection infrastructure, the same active and vocal civil society organizations caring for migrants, the same investigative journalism, or the same independent and competent judiciary. From a global north perspective, these deficiencies are actually considered an asset in migration management, as they do not hamper the swift deportation of migrants. A stark example of this trend in Europe is offered by the contrast between the very active cooperation between the European Union and neighboring countries on capacity building for migration management by the DG Migration and Home Affairs, or the Directorate in charge of Migration and Home Affairs in Brussels, on the one hand, and on the other, the absence of cooperation between the European External Action Service, Foreign Affairs, and the same neighboring countries on capacity building for national human rights institutions, which could better protect the human rights of all citizens and foreigners alike, including migrants, in those neighboring countries. There's no match. That's the political argument. The efficiency argument is twofold. First, most transit countries only reluctantly accept to actually create a refugee and migration problem for themselves, when migrants usually enter and exit their country without much fuss. I mean, that's what Turkey was. Turkey to Europe was a corridor. People entered, exited. There was no problem. And now the European Union is asking Turkey to create a Turkish immigration problem. Turkey has signed an immigration readmission agreement with the EU as a stepping stone to its accession to the EU, but doesn't effectively clamp down on irregular migration unless actively prodded by some EU states from time to time. Second, forcing transit states to combat irregular migration means that such migration will be driven underground or further underground, and that smuggling rings and mafias will control the trade, creating additional law and order issues for the authorities, the transit country authorities, and in the end, reducing the efficiency of migration controls. And the legal argument, which is pretty short, is that global north states are responsible for their actions wherever these actions take place. If they knowingly empower other states to commit human rights violations against migrants, they should be held accountable for their co-responsibility in such violations. The most blatant example of such externalization is what's been called early on, but I still use that, the Pacific solution implemented by Australia since 2001. Australia is able to get away with it for two reasons. One, it ignores the numerous calls of international human rights bodies and civil society organizations documenting the human rights violations in Nauru and Manus Island in Papua New Guinea, violations for which it could be held accountable. The Prime Minister of Australia recently said that he was tired of being lectured by the UN. Two, its political system is that of a quasi-pure British parliamentary sovereignty political system, which means that there's no constitutional human rights protection framework, which means that if parliamentary legislation is clear, The judges have no power to tell the authorities that their course of action is wrong. And that's a big difference with most of the other global North states. Canada, the US, all of the EU with the European Convention of Human Rights have a constitutional or quasi-constitutional human rights framework, which Australia lacks. For all these reasons, externalization of migration control without concomitant capacity building for human rights protections in the neighboring countries is unacceptable. And it's interesting to see in Europe that the European Court of Human Rights said so much in the MSS case when it partly dismantled the Dublin system. The Dublin system was established by the European Union to make the country responsible for the entry of the migrant on the common territory, also responsible for processing the asylum claim and for the expulsion of the migrant. And the European Court of Human Rights, which is a form of externalization on the part of the states of Northern Europe as regards Italy, Greece, and Spain, which are the frontline states. And the European Court of Human Rights prohibited Northern European Union states from sending back asylum seekers to Greece due to the appalling conditions in which they had to live there. So this was an internal externalization, which is a very interesting concept. Having said all this, we need to understand the logic of migration and the strategic choices that migrants make if we want to understand what's happening on the ground. The vast majority of migrants and asylum seekers aren't criminals or even frauds. They're trying to make the best of their predicament, which is often dire to start with. Like most of our forebears, migrants who can't see a future for themselves or their loved ones at home will seek it elsewhere. If legal avenues are open, they will use them. If not, they will find other ways, because they need to and because their options are limited. If there are refugees, they most often can't get to a host country legally. Such countries have all adopted mechanisms to prevent asylum seekers from reaching their shores, which is what has been demonstrated this morning. If there are low-wage economic migrants, their options are also very limited, mostly to trying their luck at crossing borders irregularly. And we know that irregular migration is not a crime. It's not a crime against persons. It's not a crime against property. It's not a crime against national security. 99.99% of irregular migrants are no security concern. And when you talk to anti-terrorism people, they're not interested in migration control. Too much is spent for too little result. They want targeted intelligence. That's what they want, not migration control. It's a violation. Irregular migration is certainly a violation of an administrative regulation that obliges us all to present ourselves at a specific point of entry with appropriate papers, but a crime it is not. Refugees and migrants who cross borders irregularly do not experience their crossing of the border as criminal, even if they know that what they're doing is not authorized. And we don't have the moral high ground here. Migrants are mostly courageous people who have endured a lot, who are resilient, who want to do the right thing for themselves and their families, as we would do if we had the courage to do that. And we have to recognize that irregular migration is the result of barriers, of our barriers, and that smuggling is an opportunistic industry, contrary to trafficking. Irregular migration is the direct result of policies prohibiting immigration. In the 50s and 60s, millions of North Africans and Turks entered Europe to find work. They used the ferries from Algiers or Izmir. No one died en route, and there was no smuggling. Yet there were border controls everywhere. The EU was not there yet. And it was the same for a long time at the Canadian-American border, which I remember, and at the Mexican-American border. There was little prohibition to come and look for work. Changing a tourist visa into a work permit was often facilitated. And many migrants returned home when they lost their jobs, secure in the knowledge that they could come back when the job market was again thriving. Mobility was the name of the game. With our present prohibition practices, we have opened a new and lucrative market for smuggling rings, a market which could not exist without this prohibition. Smugglers are actually implementing the labor mobility policies that our own employers in our own underground labor markets need in order to thrive. We could do that in their place. And so that's my point, and that's probably the main point. Banking on mobility would be much more efficient and respectful of human rights and cost-effective. Paradoxically, in the name of securing borders, many states have actually lost control over their borders, as flexible smuggling rings will generally be ahead of the game. With time, continued repression of irregular migration is counterproductive, as it drives migrants further underground, thereby empowering smuggling rings and leading to exclusion, discrimination, and violence against migrants. Host states, global north states, and other migration states are thus responsible for encouraging smuggling and make it more dangerous. And there are conspiracy theories about that. We can discuss that in the Q&A. Bringing unscrupulous smugglers to trial for the suffering they inflict on migrants should remain a priority, but states will not defeat resourceful and adaptable smuggling rings unless they destroy their business model, which was created when barriers were erected and which thrives at evading repressive migration policies. This is the lesson of the Prohibition era and of the lethal war on drugs. In both cases, and we know the Prohibition era in Montreal because we had a number of families that were greatly enriched thanks to your prohibition policies. In both cases, we tried to eradicate a particular behavior, thus creating a market for criminal rings. In both cases, we have come to realize that prohibition results only in loss of control over underground markets. In both cases, we changed, or are in the process of changing, prohibition policies into harm reduction policies, which include legalization, regulation, and taxation. So if we are to witness a significant reduction of human suffering at our borders, we must bank not on strict closure and repression, but on regulated openness and mobility. This doesn't negate the power of the state to expel migrants who have no right to stay. It simply means that states should adapt their policies to the facts on the ground and recognize that it is much better to create systems that encourage and incentivize people to abide by the rule and come to the border guard rather than the smuggler, rather than systems that drive massively people to evade the rule. In the end, it's much better to recognize mobility as an inescapable consequence of globalization, to offer the refugees and migrants what they need, and therefore create incentives to register officially and ultimately regain the control of entries and exits from the smuggling rings and the control of labor markets from unscrupulous underground employers. Banking on mobility means that the overall goal is to have most migrants incentivized to using official channels to enter and stay. In particular, we must respond to the needs of two main categories of persons. I know that we're here focused on refugees, but I think there are mixed flows that we must take into account. For refugees, what we need are massive resettlement policies. At present, and I'm taking the example of the Mediterranean, which is comparable to what we've discussed this morning. At present, many people crossing the Mediterranean, thanks to smugglers, are manifestly refugees, such as the Syrians and the Eritreans. We cannot expect Syrians to live in camps or cities in Lebanon, Jordan, and Turkey indefinitely, with no prospects for a better life, for educating their children, while we, Global North, stall at making a commitment to a meaningful resettlement program. If nothing else is available, refugees will take their chances with smugglers in order to provide a future for themselves and their children, as many of us would do in the same circumstances. However, most refugees would wait in line for a meaningful opportunity of resettlement in the Global North. And we're here missing a great opportunity for a global resettlement program taking as a model the Comprehensive Plan of Action for the Indo-Chinese refugees in the 80s, one could imagine, and I take a figure like this, but we can imagine other figures, 1 million refugees being selected in Turkey, Lebanon, and Jordan over 5 years with the help of UNHCR and civil society according to priority criteria, and resettle in the global north according to distribution keys of different kinds. If we take the distribution, the simple and probably not good, but distribution key of population, for 1 million refugees resettled over 5 years. For Canada, it would mean less than 9,000 refugees per year for those 5 years. And for the US, probably less than 75,000 refugees per year for 5 years, which is a drop of water in the ocean of all the migrants that both of our countries receive. This would considerably reduce the market for smugglers across the Mediterranean and the consequent suffering of such refugees. It would also reduce significantly the number of asylum applications that are being made by such refugees in European countries and the cost of processing those claims. For low-wage migrants, we need to create legal avenues for coming to our countries. Irregular migrants aren't stupid. That's something that many people don't really understand. They come here because they know that there are jobs for them. We all say there are no jobs. There are no jobs. That was true for Greece when I visited Greece in 2012. There was no jobs. That's true. But in most of our countries, there are jobs at exploitative wages and conditions. But still, there are jobs that are offered by our own employers, often in underground labor markets, that we fail to acknowledge and regulate. Global North states must wean themselves from their addiction to cheap labor. We should recognize our real labor needs, particularly in the low-wage, medium-wage sectors, and facilitate regular migration for such sectors, such as agriculture, care, hospitality, construction, sometimes extraction or fishing. By creating facilitated, flexible, and human rights-based immigration programs for such migrants, and not necessarily sponsorship programs, which often fail to respect human rights. This should be accompanied with a sharp increase in the effectiveness of labor inspections for ensuring the respect of labor law, not simply for going after irregular migrants, as well as a real effort in the repression of unscrupulous exploitative employers. This would create an entirely new framework for legal and better regulated labor markets, thus resulting in the reduction of an important pull factor for irregular migration. In conclusion, migration will be irregular if other avenues are not available, if we don't create those avenues, and if we don't change our own mindset and the paradigm upon which we operate. As long as we have not established a better system based on the facilitated but controlled mobility of migrants and on the repression of their exploitation, we will not rid ourselves from smuggling rings and unscrupulous employers. Criminalization and externalization aren't adequate answers to a normal human phenomenon. They are neither efficient, neither a good deterrence, nor cost-effective, nor human rights-based. Unfortunately, I have little hope for changes in the near future or being heard on those issues for lack of political traction. And that's a call to everyone. If you have any idea how to get political traction on those issues in a situation where migrants themselves don't speak up, I'd like to have your views. Despite numerous exactions and losses, many migrants have actually made the right choice for themselves and their families by migrating irregularly and using the services of smugglers. Be it to escape Nazi Germany, the present Syrian civil war, violence in Central America, or sheer poverty in Mali. One needs to recognize the agency and dignity of those migrants and refugees. They face very difficult choices, as well as exclusion and violence on a daily basis, and yet they endure, they persist. Migration is most often a survival mechanism undertaken out of love. And rather than trying everything we can to prevent them from coming, welcoming them in a regulated way would be a much more productive response. Thank you very much.
get first shot. You addressed this somewhat, but I wondered if you could, or if you had any additional thoughts on if you are a politician or a lawmaker, how do you respond to a popular conception among your constituents that migration is bad because it inherently leads to a loss of jobs or resources, and so your constituents simply don't want it?
That's the question I was asking you, actually. My problem is that if we look at the history of human rights, most gains have been made by the excluded minorities themselves, starting with, industrial workers at the turn of the 19th century, women in the 50 years that followed, Aboriginals in Canada and the US and in Australia, minorities everywhere, gays and lesbians more recently. They fought for their rights. They fought to be heard. They fought to gain traction on politicians. They lobbied. They spoke up. They went to court because they could, because they were citizens. Migrants have no traction on politicians because there's no electoral reward. And we should not criticize the politicians too much, because that's true of politicians whom we like with a moral compass. It's the nature of our democratic system. This is the best system we've ever invented to govern ourselves, but it works only for citizens. It works only if we're represented. No taxation without representation. Yet, migrants all pay taxes and are not represented, ever. In Switzerland, 24% of the population is composed of non-citizens. These are all people who are governed by the law, who pay taxes, and who never vote. Now, in Qatar, it's 87% of the population, but that's not really a democratic country. So let's keep with democratic countries. Migrants cannot reward politicians, cannot pressure politicians, cannot promise them votes or promise them punishment. And we have a real problem here. So in Europe, you have some ideas of votes at local elections, which also exist here in the US in different cities. I think at local level, the work, especially at the city level, there's lots of work which is being done by cities with their migrant community, including irregular migrant communities, at local level, because people know each other. But at national level, it's very, very difficult to engage politicians in the absence of a reward, of an electoral reward or punishment. We have, for example, in Canada, a leader of the opposition who is a good guy, has all the right principles, is human rights oriented, etc. He's been at the job for now over three years, and he has never, ever spoken on migration issues, because you can imagine the type of conversation he has with his strategic advisor in the morning when she says, okay, I know what you think about migration. If you say that, we're losing points in the polls. Now, I know what you should say if you wanted to gain points in the polls, but you won't say it. So shut up. And that's exactly what he's done. And he's a good guy. I like him very much, but he cannot say anything if he wants to survive politically. So how do we change that? Certainly at local level, we can do stuff. Certainly we continue to pressure, and certainly access to courts and the rule of law is key. Because judges in most of our countries, not Australia, but most of our countries, judges have the power to tell the government, no, you can't do this, on detention, on expulsion, on protection of children, on all sorts of things. And so access to justice is actually, to me, one of the key elements for, and all forms of justice, going to national human rights institutions, ombudspersons, courts, administrative tribunals. And one more element which I am trying to advocate for, and there will be an article published on that, it's firewalls between immigration enforcement and public services. People who can speak for the migrants are all the people they can encounter in social life. Teachers in school, talking about the kids, health professionals who meet migrants in their daily practice, labor inspectors, if we don't ask them to check immigration papers, the police, if we don't ask them to check immigration papers. So, and whatever, transport authorities, whomever is out there performing a public service, if we are able to make sure that they don't have to control immigration papers, first of all, that means that they will be able to perform their public service with the full support of all the community, not the community minus the irregular migrants, or even minus many migrants who will not dare speaking to them, whatever their status. But it'll mean also that they can carry the voice of migrants. So I'm trying to find those mechanisms to carry the voice of migrants when there's no space at political level. That was the typical professorial long answer to a short question.
That was a wonderful, that was a really moving speech. And go now, migration is normal in this country. With the dynamics of politics, money, and the disproportionate, in reality, the borders with Texas and to a certain extent,
yeah,
it's all happening in, a lot of it's happening in one area. And there's a lot of claiming we can't afford, we as a state can't afford to bear the brunt of all this. And yet decisions are made in Washington where there are 50 states. And most of those 50 states don't have the Texas, So what, theoretically or practically, what might be a solution there? Just take a risk because, what could work?
Okay. I don't pretend to tell any one of you what could work, so I'm not answering your question. Basically, that's what I'm saying. What I'd like to see is what I suspect George W. Bush was thinking of before 9/11 happened, which was an agreement with Mexico and hopefully with Canada a bit later on to facilitate movement through borders. And I think that we've missed an opportunity with NAFTA 20 years ago, 21 years ago this year, in facilitating border, cross-border movement of persons generally, not simply executives of companies. I think it would be time, now that we are entering the post 9/11 era, I think it would be time to think through free movement of persons across North America. And I think my idea would be, can we agree that 25 years from now, in 2040, which seems very long time, we will have freedom of movement across borders between Mexico, Canada, and the US. And we have to set goals every 5 years to get there. So, and that would be, I think, the kind of plan. I don't think there's political, it's the window for this happening is very narrow. But if we want to go beyond the present stage, which doesn't seem to work, costs a lot, and creates all sorts of human rights violations, I think that would be, to me, that would create hope that over a period of time we can manage the differences in a way, progressively in a way that will ensure that we can move through borders. I remember in the 60s going through the US border, and the only question of the US border guard was, all Canadian? I said, yes. That was it. I mean, it shouldn't be different today.
Now that we have a Latino-American presidential candidate from Florida, who knows?
And I think that's a bipartisan issue, that issue. It's not, I mean, we were discussing that during the break. It's not a left-right issue in most of our countries. It's relatively bipartisan and cuts through most of our political parties. So this is something that we can think about. I'm not sure that it has traction now, but if we work at it, it's something that it would allow us to get over the present state of permanent moral panic by creating an opening for something else. Anyway, that's a hope.
Thank you for your remarks. I found them very inspiring. I'm Shana from the Jesuit Conference again. As our presenters talked about this morning, Mexico has an amazingly progressive law on the books for migrants, for refugees, for asylum seekers, and yet that law is currently being undermined and degraded and eroded by current practice. And at the encouragement in many ways of Mexico's most powerful and nearest neighbor, the U.S. What are the international accountability mechanisms that can be put into play in order to discourage border externalization?
Well, unfortunately, not much. The issue of accountability is, I would say, is twofold. One, migrants will not ask for accountability. Migrants themselves keep mum. The best strategy of the migrant is moving on. So if you haven't been paid for 6 months, you don't go after the employer. You just change jobs. That's what you do. So they don't go to court. They don't go to unions to have the sort of proceedings. They don't do that. So we have a problem in migrants not standing up for fear. And it's an engineered fear because we create precarious situations in underground labor markets or in temporary migrant work programs, temporary labor migrant programs. So that's one thing. Second, at international level, there's not much. I mean, I'm very happy of having this mandate as special rapporteur, but what does a rapporteur do? Reports. That's all I do. So I'm a very thin accountability mechanism. I just add paper to the knowledge base. Or bits now, it's not paper anymore. I add to the knowledge base more than anything else. And that's what many of us in the human rights, for example, the UN human rights system do. The committees, the treaty bodies are doing the same thing with the periodic reporting system. And the Universal Periodic Review, where states are interviewing each other on what they do on human rights issues, well, there are recommendations. And the recommendations are taken up 4.5 years later when there's a second round of UPR. And the question goes, why haven't you done anything in the past 4.5 years on this thing? And the answer is because we don't want to. And there's nothing much more we can do. So it adds pressure. The good thing about what we do is that we're helping NGOs, the civil society, we're helping reformers inside government, we're increasing the knowledge base, adding to the tools that are out there for people to use. But in terms of accountability mechanism, like mandatory accountability mechanism, there's nothing much. Australia is brushing off most criticisms on that issue, specifically because 75% of its population approves of what they're doing, because migrants are not considered. Migrants are not part of the debate. Now, in the US, you have the chance of having a huge Mexican-American community, which is a big difference with Canada and most European countries. You have a huge Mexican-American community that votes, and suddenly senators and representatives listen. And that community, that's why you have somewhat of a debate, not on every issue, but you have somewhat of a political debate in the US that we don't find in Canada, nor in the UK, nor in France, nor in Australia. That doesn't answer your question, but it's elements.
Thanks, as I think I join everyone else. Really comprehensive analysis. The way all the elements are integrated with each other is really quite impressive. Let me add another pillar, perhaps, for you to consider, another ization, which is privatization. So you talked about the smuggling as the opportunistic industry, but on the other side of the coin, we have the vendors that are running detention, that the lack of alternatives to detention may be a profit motive there. The externalization of migration controls by ticket agents of carriers that are actually doing a great deal of the enforcement that prevents people from getting on planes. So I'm just looking in terms of how we tackle this and analyze what's out there. Where does privatization of migration control and externalization, where does that fit in terms of accountability and your analysis? How do you tackle that aspect of it?
I think it is. I mean, I was talking about conspiracy theories during the presentation, and it's not completely conspiracy theories. States have been very active at trying to shield themselves from accountability by creating all sorts of mechanisms that makes it difficult for people to go after them. So, I've asked for going to Australia. And my visit has been accepted. So I'm going to Australia the first 2 weeks of October. At the same time, I've asked to Papua New Guinea and to Nauru access to their territory and to Manus Island, etc. Silence. No answer, which is the most diplomatic way of saying no. Just don't answer. And when I've met the Australian authorities, and I told them that I counted on Australia to make sure that I could go to these Australian-funded, organized facilities, the answer was they were embarrassed, the poor two ladies who were talking to me. But they told me, which is the official line, that Australia is not in the habit of pressuring neighboring countries. Which is exactly the point. Inventing mechanisms to dilute the chain of accountability. Privatization is part of that. It's very difficult to be able to go after a guard in a private detention center in another country, etc. How can you, follow the chain of consequences and of responsibility? So it's part of the portrait. It's part of the multiple avenues that states have experimented with in order to shield themselves from scrutiny. And it works. And it works in particular because migrants are reluctant to go after their tormentors. I remember the head of the Danish Refugee Council, you may know him, Jens Vested Hansen, 20 years ago, saying that the only thing that we could do was actually to create a foundation with 1 billion euros, it wasn't euros at the time, but let's say 1 billion euros, and to flood the courts throughout Europe until governments understand. And this is not happening. There's not much money for this. NGOs, civil society organizations are doing their best. They are on the ground trying to help people, but trying to strategize collectively is difficult. There's not much appetite in our societies for helping people that are often portrayed as criminals, and this works. So what can I tell you? I think privatization is a key element for diluting responsibility. We've seen in the various war in which the US government was party to in the past 1 or 2 decades, that the use of private companies as well, private military companies, was also an element. There was the element of responsibility was also an issue. And you have some trials at present that are going through the courts. So it is possible, and we see good cases coming to courts, coming to the UK Supreme Court, the US Supreme Court on Gitmo, on the Canadian Supreme Court, Australian High Court, less so, European Court of Human Rights, European Court of Justice. So there are cases, but not, if you compare that to the potential caseload, it's minimal. So how do we get there? If you don't know, Bill, there's a little chance I know. Sorry.
First of all, on behalf of the fact-finding team, thanks for coming to the conference today and for your pretty comprehensive remarks. My question is...
Closer to the mic, please. I have difficulty hearing. Good.
Thanks for coming to the conference today on behalf of the fact-finding team. In terms of readmission agreements or third country processing or readmission agreements, Do you see any programs that are out there globally that you would advocate as being models of rights respecting? Or are all of these border externalization programs pretty much kind of passing on the buck of refugee recognition responsibilities?
Okay. I'll go into things that I didn't have time to put in the presentation, which was long enough as it was. I think there is potential for change in two ways. One, readmission agreements, which have been negotiated, for example, in the EU for 50 years. The first readmission agreements date back to the early 60s. The modern readmission agreements date back to the early 90s after the fall of the Berlin Wall, were very technical agreements to return people quickly within 2 weeks, etc. What is happening now is that the country of return is usually not very happy with the whole scheme, because it means sending back to them and dumping the problem into their hands. And they're not happy with that. And they don't implement the readmission agreements in the way that the host countries or the Global North countries would like. And so these countries are starting to negotiate. And so the EU has gone, for example, to just give an example, the EU has gone from negotiating readmission agreements to negotiating readmission agreements in conjunction with creating a migration and mobility partnership with the country, where the country gets more than simply being stuck with a problem. Where, for example, the countries like Tunisia will ask for visa facilitation, will ask for training programs, will ask for more. And in that sense, you're empowering the transit countries, and they're being empowered because they have, for once, they have somewhat of a leverage, because they can tell the Global North countries, well, if you don't agree to my conditions, well, I'll just let the migrants go through. I don't care. And so there is leverage here. And I think that transit countries are now trying, and one example in the past years, which it may be turning sour now, was Morocco. Morocco had an agreement with Spain and the EU, has implemented 3-4 years ago a much better immigration policy, has offered sub-Saharan Africans who were on its territory opportunities for legalization in Morocco, or for safe return with money to create new businesses. It had developed something new, something interesting. So I think the transit countries, but we're at the very beginning of this. And this hasn't really developed yet into a full-fledged negotiation. It's an unbalanced negotiation. The second element of where I think there is some kind of hope, but it's long-term. All these issues are generational. We're not going to solve this within the next year. It's going to take 25 years. When another generation will be in power, and that other generation is used, your generation, students here now, you're used to diversity. You're not scared by a Latino neighbor or friend, etc. It's in your culture. It's part of who you are. It's not part of who I was when I was a child in Montreal in the 60s. And so this is something that I've had to learn. For you, it's different. And I think that will make a difference over time. So that being said, I think what states are experiencing now, and especially politicians in our countries, they are experiencing the limits of what they've created in the past 25 years. The scare about the terrorist migrant, the scare about the plombier polonais in France, the scare about the frauds committed by migrants. At one point, it doesn't serve their interest, especially if they're mainstream. It serves the interest of Marine Le Pen and Nigel Farage and the Jobbik party in Czech Republic. that's where things are going the wrong way for many mainstream politicians on that issue. They've sort of lost the momentum. They don't control the debate. They don't create the terms of the debate. The terms of the debate are created by nationalist populist parties. And mainstream politicians are, I think, on the verge of trying to regain momentum on that. And where can that come from? I think that at multilateral level, very high up in the stratosphere, the things like the Global Forum on Migration and Development, which has been meeting for the past 8 years outside the UN, controlled by states, is creating a conversation between states which goes way beyond preventing irregular migration. It goes into development issues, human rights issues, etc. And it's developing a narrative which could empower some politicians in the foreseeable future to change the tone of the conversation and try to marginalize the nationalist populist discourse, because it creates a much more sophisticated discourse on the benefits of migration, on why mobility is a good thing. And so it could be that it might empower those politicians to create something new, especially if they're able, for example, in Europe, to say that this is Brussels-based. Oh, it's not for, it's not my fault, it's Brussels that says so. But they all agree to make sure that Brussels says so. And that's the type of quid pro quo that actually has worked in the past for Europeans and could work on that issue as well. So there are small modicum of hopes out there.
I think with that, we should adjourn. We'll take a short break. There's some coffee. Please let me... Thanks, everyone. We'll resume now with the second panel, which will focus more closely in on the role of the United States, and particularly looking in at the way in which U.S. law, policy, and practices might evolve or change in order to ensure consistent access to humanitarian protection and protection of human rights in the context of the broader policy discussion that we've been having today. I'm delighted that we're joined by a distinguished panel who bring great base of expertise and represent a number of different sectors. I'll introduce them briefly, then I've given them a very difficult task of addressing this incredibly complicated issue through short opening remarks, but that's because I'd like to facilitate a discussion among our panelists for a chunk of the time that we have before opening it up to questions and answers. So first, directly to my left, joining us from the White House National Security Council is Ronald Newman. Ronald's the Director for Human Rights and Refugee Protection at the NSC and previously served as an attorney advisor within the United States Department of State Office of the Legal Advisor. Mr. Newman received his BA summa cum laude in Business Administration from Morehouse College and a JD from Yale Law School. To his left is Shelley Pitterman, the regional representative for the United Nations and the Caribbean for the UN High Commissioner for Refugees. Mr. Pitterman is based in Washington, D.C. and joined UNHCR in 1984 as a program officer in Sudan. Since then, he's managed UNHCR field and country operations in Guinea, Burundi, and Kenya, and also served as the Director of Operations in Jordan for the UN Relief and Works Agency. Mr. Pitterman has held positions in UNHCR's Geneva headquarters, including as Chief of Resettlement and as Director of Human Resource Management before taking up the assignment here in Washington. Mr. Pitterman went to Brandeis University and earned his MA and PhD from Northwestern University. To his left is Shana Aber, Policy Director at the National Advocacy Office of the Jesuit Conference for the Society of Jesus in the United States and Canada, and I should mention also an alumna of this law school. Shana works there to coordinate efforts at fulfilling the social justice mission of the conference, together with U.S. and Canadian-based Jesuit institutions and Jesuit-affiliated works abroad. The office's priority issues include human rights in Honduras, U.S. policy towards Central America, migration and immigration, U.S. criminal justice reform, domestic poverty, and corporate social responsibility. Shana also currently serves on the board of directors for the Latin American Working Group and the Ignatian Solidarity Network. Previously, she worked at Jesuit Refugee Service USA, where she was responsible for advocacy efforts aimed at improving the lives of refugees and the forcibly displaced in Latin America and the Caribbean. Shana holds a BA in Latin American Studies from Macalester College. Next to her is Jennifer Podkul, the Senior Program Officer for Migrants' Rights and the Justice Program at the Women's Refugee Commission, also an adjunct professor of law at this law school. She works there to advocate for policies designed to protect women, children, and families seeking protection in the United States. And prior to joining the Women's Refugee Commission, Professor Podkul worked as an attorney providing representation to immigrant children in Immigration and Family Court, first as an Equal Justice Works Fellow at IUTA in Washington, D.C., and later as a fellow with Kids in Need of Defense. She's a national expert on issues affecting unaccompanied immigrant children and has published articles, handbooks, and reports on issues related to immigration policies in the United States. She served as a Peace Corps Fellow and volunteer in Honduras and holds a Bachelor's in American Studies in Spanish from Franklin and Marshall College and a JD with honors from the Washington College of Law at American University, where she was a public interest, public service scholar. Finally, our last speaker in the initial portion of remarks is Bill Frelich, the director of the Refugee Policy Program at Human Rights Watch. Since 2005, Bill Frelich has served as the director of that program, and his work involves monitoring, investigating, and documenting human rights abuses against refugees, asylum seekers, and internally displaced persons worldwide, and he advocates for the rights of those forcibly displaced persons. From 2002 to 2005, Mr. Frelich was the director of Amnesty International USA's refugee program, and previously was the director of U.S. Committee for Refugees, where he served for almost 18 years. He's traveled to refugee sites throughout the world and is widely published, was the editor of USCR's World Refugee Survey and monthly refugee reports. He taught in the Middle East from 1979 to 1983 and was coordinator of the Asian Center for Clergy and Laity from 1976 to 1979. He has a bachelor's from Oberlin College, Phi Beta Kappa, and a master's from Columbia University. So we will, as I indicated, proceed to talk a little bit about both existing laws, practices, and programs, as well as new methods of implementing approaches to migration management, to humanitarian protection, and rights protections that ensures the respect for the fundamental rights of migrants, beginning with Ronnie.
Thank you, Ann. I guess I should note from the start that I've been battling with my allergies a bit recently, so I will endeavor to keep my coughing to a minimum while I'm on stage this afternoon. As Ann stated, my name is Ronnie Newman, and I'm Director for Human Rights and Refugee Protection at the National Security Council. I've worked on issues relating to refugee protection and migration within the U.S. government for roughly 5 years now, and I've played a fairly involved role in helping the USG work through its response to the recent surge in migration up from Central America, and I know that's the central topic for our discussions here today. I'm excited to see so many people here in the room ready to engage and talk about refugee and protection issues. I work on a range of things beyond refugee and migration issues, but this is far and away my most cherished portion of my portfolio, so I'm happy to see you guys excited and interested in the topic as well. I'd note at the start that the United States has a long-standing tradition of seeking to promote the interest of refugees and vulnerable migrants, both here in the Americas and beyond, and seeking to promote the principles enshrined in the Refugee Convention. Over the years, that commitment has been demonstrated in a range of ways, including through our refugee admissions program, which has brought in more than 3 million refugees since 1980. That commitment is also borne out in our bilateral assistance to other countries, as well as our funding of international organizations that work on capacity building and technical assistance relating to refugee protection. As a government, also in this space, we engage on issues relating to migration management and border security more broadly. And that is another place where we spend lots of time and we spend a fair amount of resources, and we seek to engage countries on a regular basis. In that space, our interests also involve things like the prevention of drug trafficking and other illicit conduct. And so there is a degree to which these two spheres come together, and I think we'll explore that a bit this afternoon. The surge in migration up from Central America that reached its peak last summer brought our various programs and initiatives, including relating to development and good governance and citizen security, into sharper focus. And the surge also raised the question of whether we should be doing more. On that front, we have responded with what we view as an integrated and comprehensive approach that seeks to address the underlying challenges relating to economic issues and governance issues and security issues in Central America. Notably, that approach includes a $1 billion request in the President's FY16 budget, and so hopefully Congress will work with us on that. In addition, we have reallocated some of our current assistance funds to see if we can more immediately get at some of these troubling issues. But at the core of all of these efforts has been our longstanding commitment to protection-related issues, and our response has included efforts both domestic and abroad to improve access to protection. So, for instance, here at home, we've funded a variety of efforts seeking to ensure that minors and other vulnerable migrants can get access to counsel as they're being processed through our immigration system. We've also strongly encouraged external parties, including perhaps many in the room here, to engage from a pro bono perspective to also help this vulnerable population. Abroad, among a number of things, we have established a refugee and parole program to seek to reach vulnerable children in Honduras, in Guatemala, in El Salvador, many of whom might otherwise take that dangerous journey up through Mexico that we saw so many children, that we've seen so many children take over the recent few years. And through that program, we won't be able to reach every single child in Central America, but we do think we can provide an opportunity to get some children out of harm's way. Even with the recent push, which I've tried to outline in basic form, I think everybody recognizes that we'll need to continue to engage for several years in cooperation with governments in the region, international organizations, private donors, the development banks, civil society, to get to a place where the region as a whole is on a more positive trajectory. But again, rest assured that throughout this process, we will work to make sure that protection-related issues stay top of mind. Look forward to engaging more on these issues and getting in a back and forth with the other panelists and also with the audience, time permitting. With that, I'll give the floor to Shelley.
Thank you. Thank you very much, Ronnie. Appreciate it. I will come with a general perspective on what has been happening in UNHCR's interest over the last year, but even actually before the upsurge last year in the number of children and asylum seekers crossing the border. So as many of you know, but just to be sure, that UNHCR is the UN agency that's responsible for ensuring protection and the rights of refugees, asylum seekers, and stateless persons the world over. And when there's an increase in migration flows, like the one that we're seeing and have seen in the Northern Triangle, our job is to work with governments to help understand why people are leaving, to understand the dynamics of forced displacement to the extent that that's an element of the flow, and to support governments and advocate with governments to respond appropriately. Now, this requires the introduction of a robust identification and screening mechanism so that we're sure that people who are in need of international protection are properly identified and that they're not summarily returned without having the opportunity to seek asylum and without having the opportunity to seek access to procedures. In the context of last year's flow, there was a pretty immediate conflation of the flow with illegal, irregular movements, and the refugee narrative was lost, essentially, from the beginning, and I think it's important to highlight that in terms of the public response as well as, to some extent as well, the government response. The situation of the displacement of unaccompanied children, both unaccompanied and accompanied, including families, is now, I think, better, well documented in terms of the actual motives for movement. The refugee dimension is now clear in the sense that this is the most dangerous world that's not in active interstate conflict. We're dealing with non-state actors. The highest rates of femicide in the world, endemic violence, impunity. El Salvador, which is about the size of Massachusetts, had 481 homicides last month, the highest in a decade. We did a report that was mentioned earlier this morning called Children on the Run, that based on individual interviews demonstrated that about 60%, whatever the actual number, it's a significant piece of the population of children, had what we would consider to be a refugee story. But since then, the numbers of children who've been screened by DHS, the Department of Homeland Security, for credible fear reflects 70% do have a credible fear. Those cases are now going through the immigration process and will be seen increasingly by immigration judges. There was also a significant increase in the number of asylum claims, not just in the United States, but also in Mexico, in Belize, Nicaragua, Costa Rica, and Panama, though the numbers were substantially lower. So UNHCR's position is that there has to be a regional solution. It requires a robust regional protection solution, and this requires all governments in the region to build up protection systems as well. In one of the first meetings that the Secretary of Homeland Security convened with NGO partners and others on this, there was a metaphor that the house is burning, and this was in juxtaposition to the assertion that we had to stem the tide. And the conclusion was that even as we try to put out the fire, so to speak, we have to help people who are who are fleeing from the burning house. So the refugee narrative seems to be taking a little bit more ground now. As Ronnie mentioned, there's a program for in-country processing of children who have refugee claims. There's talk about violence more explicitly. It's not just reference to the business model of smugglers, which was a predominant theme last year. And there's a recognition as well that the states involved, El Salvador, Guatemala, and Honduras, really lack state authority and are perhaps even to some extent complicit in the violence that's leading so many people to leave. And so the focus, quite justifiably and most welcome, of good governance and accountability in the billion-dollar proposal that the government of the United States has put forward. So we're really very happy about that, to the extent that our joy matters. But more importantly, it's a recognition of the shift in the narrative. So what we would like to stress is that ensuring international protection is law enforcement. It is the law of the United States to provide international protection to asylum seekers. And so therefore, any support for increased border enforcement should include strengthening the mechanisms to ensure that those fleeing persecution and torture, victims of human trafficking, and others in need of international protection are properly identified and not turned away, but rather given meaningful access to protection. And this applies just as well in Mexico and any other country, Turkey, Jordan, around the world, where there is evidence of movements of people in need of international protection. And I'll mention here that since it's come up earlier with respect to detention, that Article 31 of the Convention on the Status of Refugees very clearly states that individuals who are seeking protection should not be penalized for irregular entry. And this is one of the legal foundations for UNHCR's position, although it's already been stipulated in other respects, for example, in terms of basic child protection as well, that families, mothers, children should not be held in detention, especially for deterrence purposes. This is an issue that Ronnie and others here at the podium know has been a subject of considerable interest. Strengthening border enforcement, either in the United States or in the neighbors south of the border, in response to a well-documented refugee influx, compels people who are fleeing for their lives to pursue dangerous alternatives that could have fatal consequences. And so therefore, while the Secretary of Homeland Security has published statistics that reflect a significant decrease in the numbers of apprehensions by Customs and Border Protection, we really don't know now, since there is this aversion perhaps to apprehension. We don't know how many people are crossing that are not being recorded. And we get back into a hidden population, regrettably. Last year, you'll recall the pictures of children presenting themselves to the Border Customs and Border Control, Border Protection authorities, getting bottles of water, getting support, and then being brought into facilities. There, the story changed, of course. UNHCR is very concerned any time that a government response to a refugee situation is to rely solely on containment measures. This type of response creates more barriers to protection for those fleeing violence rather than ensuring the basic requirements of the Refugee Convention, which is access to legal avenues to reach safety and refuge. I would like here, nevertheless, to acknowledge that there has been an effort to reinforce the affording legal counsel to children in particular who need legal representation as they go through the complex immigration system, and I'm sure others will speak to that after I do. I'd like, for those of you who perhaps aren't aware, to cite two recommendations that have just been published by the Migration Policy Institute in a report that they've put out called Unaccompanied Child Migration to the United States. Just came out last week, and there are two relevant recommendations that I think reflect as well a bit of a shift in MPI's appreciation of this situation. The first is, and I'll just quote, "In the absence of careful screening for humanitarian concerns, strong apprehension and detention programs strengthen enforcement but undermine the protection of vulnerable groups." We're very pleased to read that from MPI, and notwithstanding the political imperatives in the short term, we hope that perhaps in the course of the summer and the fall, there will be renewed interest on the part of the authorities here to really promote and invest in alternatives to detention and to the release of asylum seekers, of folks who have gone through the credible fear and who should be individually reviewed and released as a result of that review. The second recommendation is that the United States should not support efforts to apprehend and return immigrants in transit without ensuring that they have a genuine opportunity to seek humanitarian relief. U.S. support for adequate humanitarian protections within Mexico and Central America is especially important to the extent that enforcement, I'm sorry, this is a misquote here. I'll just stop at Central America. And I mention that because there has been reference earlier this morning to the possible collusion between the United States and countries in the South, and to what extent that represents a violation of international law by the United States. Not being a lawyer, I will leave it to others to judge, but nevertheless, I think it does color our appreciation of what is otherwise a pearl in the international arena, and the United States should reconsider its approach to enforcement on the southern Mexican border and the way that it approaches that phenomenon these days. So I'll stop there with that critical insight, and look forward as well to any comments and questions that you might have, and to the debate that will ensue. I should also mention that it's really quite an honor to be here, given the distinguished reputation of Samuel Dash. So thank you very much for having me.
Thank you, Shelley. Shana?
Thanks. In order not to kind of duplicate the remarks that I think some of my colleagues are going to handle, I'm really going to focus on two aspects that I think haven't yet been elucidated. That is the country conditions facing children and families that are currently making the choice to flee because of violence from the Northern Triangle of Central America, and some of the things that we've seen on the ground that are now very much in their way as they try to seek safety and security beyond the borders of their countries of origin. I think that the report that was presented this morning was very well entitled, "The Cost of Stemming the Tide." The media narrative that we heard this summer, the narrative that came out of Congress, the narrative that came out of some sectors of the administration was very much about stemming the tide, and it undermined the I think understanding that we all share as a country of refugees, of immigrants, of trafficked people, of internally displaced people. I think I've covered every single group of people who are who can claim ancestry and are currently residing in the U.S. The understanding that we all share that the cost of locking the door to a burning building, the cost of stemming the tide when people are seeking safety is the lives and well-being of children, the lives and well-being of refugees. And we have, unfortunately, with our partners on the ground, had the opportunity to document some of the cases in which the lives of children have been lost because of refoulement of people who are seeking protection in Mexico. A word on the violence that is now widespread throughout the Northern Triangle. The violence in the Northern Triangle is definitely something that can be attributed in large part to gangs, to organized crime, but it also stems from an infiltrated and complicit state in some cases. I will speak to the country that I know best in the region, which is Honduras. In 2009, there was a military coup which swept out of power the democratically elected government. It also meant the dissolution overnight of government institutions and the reconstructing of those institutions. But at the same time, that reconstruction of the institutions allowed for the deep infiltration of the state by organized criminal actors who took advantage of the chaos. What governs in Honduras is really the law of the strong rather than the rule of law. And the government of Honduras has definitely seen in the media spotlight around the children and families who arrived fleeing violence an opportunity to press forward some of the very plans that they already had in place for security and economic development of the certain kind that they had already kind of been dreaming up. At the same time, the children and families who arrived on our border and who kind of came into the media spotlight this last summer presented a political inconvenience for leaders here in the U.S. And I think that a lot of what we saw, kind of the fallout of the media spotlight, has been a real investment into the infrastructure of control, the infrastructure of enforcement, border control, all the way down to the border of Honduras, and very little attention and very little energy put into the infrastructure of protection, of saving lives, of rescuing people, and in fact, we've actually invested in trapping people into their own countries of origin, even when their lives are in danger. I wanted to also kind of bring to mind two stories that stick with me of two young women, two girls actually, who came to the attention of our partners in Honduras. One I'll call Leticia and the other Lisa. Leticia was a story that I came across last April, a women's organization who works very closely with an investigative journalism outfit run by the Jesuits in Honduras, was up visiting Washington in April. This is before the media spotlight really hit the kids and the families. Our Border Patrol stations were not yet overwhelmed to the capacity that it presented an interesting news story. But this women's organization was up in town, specifically looking to find out if there were ways to partner with the U.S., partner with U.S. Domestic violence institutions to build a network of domestic violence shelters where they could get girls and women at risks. And they presented to us one particular story that I've carried with me ever since. They presented the story of a young girl, an 11-year-old, who lived in a gang-controlled neighborhood, who one morning was dragged out of her house by a group of armed men who controlled her neighborhood, who was raped by 16 men as a birthday present for the gang leader, and who fled that circumstance, was told that she was then the gang girlfriend and would be expected to give herself to the gang and be sold on behalf of the gang from there forward. She fled that circumstance, went back to her family's home. Her family sought protection from the police and told her story to the police, and that very night began to receive threatening phone calls. The content of those phone calls led them to the conclusion that the police were complicit with the gang, which they believed to be the author of the threats. And they turned to NGOs, knowing that they couldn't trust their government, in order to get their daughter to safety. The NGOs on the ground only trusted one women's shelter in Honduras. The other women's shelters they knew to be either insecure or be used by some state authorities as brothels. And when they turned to the one women's shelter that they trusted, that women's shelter said to them, "We can't take a case that has any links to gangs. We are too afraid that our other beneficiaries would be put in peril. You have to get her out of the country." And so they did. That's the choice that those parents made in order to save the life of their 11-year-old daughter. I am afraid that the current way that we are investing in the infrastructure of immigration control is endangering the lives of girls like Leticia. The other story, the story of Lisa, is the story of a 17-year-old girl, also from San Pedro Sula, also who lived in a gang-controlled neighborhood, who came to the attention of a gang leader, an adult man, who kind of lured her to his house. She went and lived in his house for a week until she witnessed the rape and murder of her best friend who attended school with her and who also had come to the attention of that gang. Lisa was then rescued from the house by her father, who came to find out where she was. And then after he got her out of the house, he and the family began to receive death threats. Understanding that his neighborhood was controlled by the gang, he tried to relocate internally in Honduras, but found that the gang was pursuing his daughter. She too was considered a gang girlfriend. He then sent his wife, his young son, who was, I believe, 9 years old, and Lisa north, looking for protection. They ended up in Mexico. They actually found an NGO who was in the process of filing a humanitarian visa application for them when they were arrested and detained by Mexican authorities in September and returned to Honduras, where they currently live in hiding. The children no longer attend school. Their lives are very much in peril. We have invested in all of the wrong programs with all of the wrong partners. And I think that now is the time for us, as our nation's soul is tested, and I think I can speak in that way, representing a religious group, but as our nation's soul is being tested, we need to reinvest in the idea of America that we know to be, the place that embraces people who are in need of protection, the place that has committed internationally to refugee protection, and that seeks constantly and consistently to remind other countries that our duty is to protect the stranger, to protect those who are fleeing persecution. Now I'll turn it over to Jen.
Thanks, Shana. So I'm here today representing the Women's Refugee Commission, and we're a research and advocacy organization that looks to protect the rights of vulnerable migrants, specifically as the Women's Refugee Commission of women and children who are migrating throughout the world. This issue of unaccompanied children fleeing Central America and coming to the U.S. seeking protection really came on our radar in 2011 when the numbers really started going up. Unaccompanied children from Central America have been coming to the U.S. for years. The numbers really started to spike in 2011, and we did some research, talking to children, doing a lot of research on the country conditions, as Shana so eloquently described to us. You know, our prediction was these numbers of kids coming here seeking protection was not going to go down. Our research only looked at the migration of unaccompanied children, but it's not surprising that it hasn't just been unaccompanied children who've been coming to the United States looking for protection, but that it's also been families. You know, all the reasons that kids are coming here and trying to escape from their homes and seek protection here are the same reasons that a mother is going to pick up and leave her community and come here with her very small children seeking protection. We've seen the numbers ebb and flow. You know, everyone's been monitoring and looking very closely what the numbers are doing right now. The number of unaccompanied children are a little lower than they were last year. The number of family units may have dipped a little bit, but they're incredibly high right now. And I think what's really interesting about that is that the way these populations migrate are often very different. I think, you know, there's been a lot of attention, a lot of movies made, a lot of photos of people riding the trains up. I think traditionally it was, you know, a lot of men who were doing that and young boys who were doing that were strong enough to do it. You know, it's a lot harder for a woman who might have a 5-year-old and a baby that she's carrying to hang on and stay on top of the train. So even before the surge and before the crackdown in Mexico, the migration patterns of women and children were often different than for other migrants, particularly ones who are looking for economic opportunities. Women tended to kind of have more underground routes. They would pay more money, maybe using false documents and trying to go through ports of entry as opposed to seeking to evade border control and going between ports of entry. And I think what's happened with this crackdown has been really interesting is that, you know, the traditional ways of people to get through Mexico have forced these populations even further underground, and our concerns are that it's making them even more vulnerable. You know, example of that is if a person can't predict how they're going to get somewhere on a route that's been used for years, they can't anticipate using shelters that have been set up by NGOs that can provide food, that can provide water, or medical care. They're pushed into either more dangerous territories that could be controlled by international criminal organizations. They're not going to have access to the services that they need, but they're also going to be more vulnerable to people who want to exploit them. You know, example is there was a 16-year-old girl who needed to leave her country of Guatemala, and the mother had no money to send her away. So what she did is she came to an arrangement with a smuggler where the mother, in a sense, really had to sell her daughter, and the agreement would be she was going to stay in Mexico and be a girlfriend of somebody for a while, and then she'd be allowed to continue on her way. But by the time she got to the United States, she was already pregnant as a result of being forced to stay as the girlfriend of somebody in Mexico. You know, our concerns about the U.S. response to this has been an enforcement-first response. I think we all have the same goals. Nobody wants to see a child have to leave their community, leave their home, and go and take an incredibly dangerous journey. Nobody wants that. We can all agree on that. I think where we disagree, and where the Women's Commission has disagreed with some of the decisions that the U.S. government has made in this, is how you're going to go about trying to keep that child at home and trying to keep that child safe. I think this idea that the administration has used to rely on deterrence as a way of stopping these children from undertaking a dangerous journey, we definitely don't agree with it. I think these campaigns, these radio advertisements that say, by the way, it's really dangerous to send your child through Mexico, I think everybody knows that. I don't think that's really going to stop somebody who's making a decision whether or not their child's going to live or die. A radio ad informing them that it's dangerous to send them probably isn't going to change their mind. This idea of increasing enforcement and the dramatic increase of detention, particularly in the United States, of family detention where we're locking up women and babies. We're going to have thousands of beds now in these brand new facilities that are intended to hold women with their babies. I think this is the wrong way. I interviewed a child who had come to the United States, and he eloquently put it. He said to me, he just looked me dead in the face and he said, "If I stay at home, I will die. If I try to come to the US, I might die, but at least there's a chance." I mean, what can you say to that? You know, telling that child that you might be detained when you get here, or hearing a radio ad where it says, by the way, it's really dangerous to try to make that journey, that's not going to change that child's mind. And it probably shouldn't. We probably should make sure that the child can get somewhere where they can be safe. I think what we need to think about is, you know, because these are our neighbors, these countries are our neighbors, Central America, we've been looking at this as a migration issue. We haven't been treating it. The United States has not responded in a way that we respond to other refugee crises around the world. And so I think we need to kind of step back and not consider this, it's just that our neighbors are having problems, but really step back and say, what if this was in the Middle East, or what if this was in Africa? You know, we would have a different response, and we would have, you know, less of a deterrence goal and more of a protection mindset. This isn't an immigration matter, right? This is a refugee matter. I think the difficulty is that the increase of these numbers happened at the same time that the U.S. government and the Obama administration was really trying to be successful on comprehensive immigration reform in the United States. And I think it really conflated this issue of immigration and immigration issues and having a big political win and getting everybody on both sides of the aisle to agree on reforming immigration. At the same time, we saw an increase in refugees seeking protection in the United States. And I think that was really unfortunate because the response was we need to really crack down on this population so that we have the political space to win on comprehensive immigration reform. I think the other unfortunate thing was the rhetoric around this. Everyone was referring to this as a border crisis, that this was a crisis that was happening on our borders. You know, I think the reality is the crisis is in Honduras, the crisis is in El Salvador. There was no crisis on our border. The crisis was we had a lot of kids in Border Patrol stations because the government hadn't ramped up enough systems to deal with the populations that were coming here. 68,000 kids in the United States of America is not a huge number. It's a drop in the bucket. That's not a crisis. But when you say there's a border crisis, the reaction is, well, then we need a border solution. So all the political response to this has been, what's the border solution to the border crisis? Well, the border solution has been, we need more boots on the ground. You know, we need to close up that border. It's been, let's roll back the Trafficking Victim Protection Act that provides certain protections for children. That's been the response. The response has been, let's cut funding for these countries unless they can guarantee that they're not going to send migrants to us anymore. It's kind of been these low-hanging fruits that really has been shaped by this rhetoric of us having a border problem as opposed to how do we deal with an international refugee situation, international humanitarian crisis. I think what we need to do is really focus on, I think there's an opportunity with the renewed attention on this and the administration requesting, you know, this $1 billion to deal with the root causes of this problem. I think this is a great opportunity. I think we have to watch very carefully, you know, are we going to get this money? How is this money going to be spent? And ensuring that it's going to things like building up child welfare systems in these countries. And when we're doing trainings of other countries to help support their border enforcement, that our training includes screening mechanisms and protections and how do other countries do this? Because we have this information here and we need to be able to export that to other places. I'll leave it there, and I'm happy to engage in this conversation further.
Again, thank you for the invitation as well. As Ian's introduction of me suggests, I'm sort of an old geezer. I've been around for a long time, and one of the things he asked me in advance, so give some historical perspective and global perspective from Human Rights Watch, and in 5 to 10 minutes. So, but I do come at this with a long history, basically, looking at externalization as something that's been going on for a long, long time, and something that is currently going on by, sort of a number of key destination countries or blocks of countries. The European Union, we've already heard a lot about. Human Rights Watch, over the course of the last 10 plus years, almost every year has been issuing report after report after report on Ukraine, on Turkey, on Morocco, on the EU external frontier states, pushbacks at borders, on and on and on. And this whole, I think somebody used the word conspiracy earlier today. But we see, we see patterns and practices that apply in the European Union, that apply in Australia, which we've heard about, that apply in Israel, here in the United States and Canada, and where you can clearly see that they're looking at each other's playbooks, basically. And there's a lot of copycat going on, both historically in terms of what we've done before and picking up on different strands as we look internationally. And so the context of what I want to sort of highlight is the notion of interdiction and how interdiction plays hand in hand with a number of key concepts that often have the gloss of humanitarianism or the gloss of rule of law. But at the end of the day, it looks like these are efforts to basically block people from fleeing for their lives and escaping in the name of managing migration and the name of being orderly and legal in the approach. And a couple of concepts, I mean, there's the safe third country concept, the idea that, yes, you're a refugee and you need to be protected, but you could have applied for asylum in some transit country before you got here. And so we're going to prevent you from entering, or we're going to send you back to that transit country. And I heard this most recently. I did a report on Bulgaria. It was called the Containment Plan, which I think sort of says a lot in the title right there. They actually had explicitly a plan to keep Syrians out of Bulgaria, building a fence and pushing people back, oftentimes using excessive violence. And when I met with Bulgarian officials, they basically said, well, but it's not refoulement. We're sending them back to Turkey, and Turkey's a perfectly safe country. Notwithstanding that Turkey has a limitation on its accession to the Refugee Convention that excludes non-Europeans as even being considered to be refugees. We've heard the same thing when we've dealt with the fence at Ceuta Melilla with respect to Morocco, and we see improvements. I mean, yes, there have been improvements in Morocco. There have been some improvements in Turkey, but you get just enough of this what's called capacity building to say, bingo, okay, now it's safe to send people back. And one of the concerns we have with the current program with Mexico is, you see some capacity building, you see some improvements, a little money thrown the way of Comar, a few more OPs that get hired or whatever it might be, and you reach this sort of, have we reached the critical mass where we can now say it's safe and people can be handled there. The other concept that's closely related is the safe country of origin, or if you don't have a whole safe country of origin, you have an internal flight alternative within that safe country. Or if not that, you've got in-country processing of some sort that takes place even within a dangerous country that we will, pinpoint and somehow rescue a few kids here and there, as the first speaker mentioned, that we have such a program to prevent children from going on a dangerous journey, but we won't be able to reach every child. Well, in fact, the children that we just heard about, Letitia, wouldn't qualify for this program. She wouldn't qualify. She doesn't have a lawfully present parent in the United States that would be that would be able to qualify, to be eligible to petition to save that child. those who are lawfully present in the United States will have to be able to put up $650 of their own money for DNA testing, which might get paid back eventually, but they have to go through a long process of interviews, of medical exams. The form itself that needs to be filled out, we just heard took about 3 hours for them to fill out the initial form, just establishing the relationship. And then the key problem, the contradiction at the heart of this program, the catch-22, if you will, is that the child who lacks state protection, as we've established, gangs are threatening the child's life, that child has to qualify as a refugee, as having a well-founded fear of being persecuted in order to qualify for the program. But if they qualify, they're not protected while the claim is pending, and it will take months and months and months. And in fact, the program started in December, and there's still not a single child that's been admitted to the United States. We don't even know how far along any of them are in the process. Or you don't qualify, in which case, let's just have a family reunification program and call it that, and perhaps make it a broader program of family reunification, but don't put the gloss of protection on it. Let's not call this protection. Let's not feed into that narrative, because essentially what it's doing is it's basically saying to people who are fleeing for their lives, go back and wait in line. Now, Francois mentioned wait in line as an idea. That's an idea that's an appropriate idea if there's a third country. If you're in a refugee camp somewhere, you can wait in line. But we're talking about in-country processing. We're talking about people who are under threat and are not being protected during that period while their claims are pending, being told go back to wait in line. Don't take this dangerous journey. And that's the other issue, is this sort of humanitarian gloss, the humanitarian alibi, the notion that we're doing this for your own good. We're preventing you from hopping on a boat from Haiti and going on a dangerous rickety boat or into the Mediterranean, or we're helping you from getting onto this dangerous freight train. Well, the fact of the matter is, you may be fleeing something a whole lot more dangerous. You may be fleeing a direct threat to your life. And who are we to basically say that because it's a dangerous journey, you shouldn't take it at all? There is a fundamental human right. It's in the Universal Declaration of Human Rights. It's in the International Covenant on Civil and Political Rights. No one ever talks about it anymore, but it's the right to leave. The right of any person to leave any country. That's the right. When we think about walls, for God's sakes, the first wall we think about is the Berlin Wall. It was constructed to keep people out. But now we have the walls that Bulgaria is building, that Greece is building, that Spain is building, that the United States is building, that Israel is building, that indiscriminately are keeping people out without knowing what their stories are, without knowing what their fears are. And then we're reaching beyond those fences, and we're interdicting them, and we're summarily returning them, because these interdictions, and we just saw in December 2014, the Australian government actually removed the references to the Refugee Convention from their law because of the Sale decision in the United States, basically saying that this is just a statutory element. The Refugee Convention isn't self-executing, and so this is just as a matter of statute, we will elect whether or not we commit refoulement. And so again, here taking the page from the U.S. playbook, basically applying it to Australia, which took Guantanamo and basically created Papua New Guinea's Manus Island and Nauru. We created the safe third country of Guantanamo, believe it or not, in parking Haitian refugees there. And the notion of in-country processing, guess what? Haiti again. When the Supreme Court lifted the injunction on interdiction in January 1992, that was the same month that in-country processing started in Haiti, when interdictions resumed, the same exact month. And what you had was a system where, and when President Clinton became president, he announced, I'm going to continue the interdictions, and everyone has the opportunity to go back and line up in Haiti and apply for this in-country processing program. And you had more than 100,000 people that applied for a program. And they had to go through the 4 processes of interviews. They had to go through, the whole rigmarole of the processing. Of the more than 100,000 people, there were about 30,000 claims that were ever even processed. Of that, about, I've got the number here, it was 10,644 cases that were decided, 9,827 denied, an approval rate of 7.7% of cases decided, which was the tip of the iceberg of the number of people that even applied for the program in the first place. I was there at the time. I was in Haiti. I saw people that were queued up for in-country processing, and I saw them being threatened. I saw the Taton Makut that were harassing them. I saw a program that was a sham. Basically, it was a pretext for interdiction. It was a pretext for sending people back. And I submit to you that the in-country processing program that's being touted right now as protection for Central American children is an exact smokescreen pretext for interdicting, not on sea, but in Mexico, using safe third country, using in-country processing, throwing whatever sticks to the wall, basically, as a pretext for stopping that image of children in Texas that are overflowing detention centers, because that's a political liability. I think it's completely cynical, and I don't think there's anything humanitarian about it. Thank you.
Well, thank you to everyone for providing those remarks. I think that there may be some things there that perhaps Ronnie and Shelley might like to respond to in turn, and then we'll just open it up to discussion. So, Ronnie, anything?
Okay. I feel like we covered quite a bit of ground in those intro comments, so I won't attempt to respond to all the points that were made, but I may touch on a couple as the conversation continues. I guess I'd note to begin that the bill suggests that he is the old geezer, but I will note for the record that he still has hair. And I don't. But another thing that the bill suggested was that our in-country program in Honduras and El Salvador and Guatemala was a smokescreen. And my sense is that is perhaps too harsh a light to shine on a program that we feel will provide protection to actual, real children in the Northern Triangle region, and a program and a type of program that we have employed in the past to genuinely important results. To note but one example, we've run an in-country refugee program out of Iraq for the last few years, and in the last couple of years, we've brought 9,000 to 10,000 people to the United States through that program. It was last October or so that I traveled out to Boise, Idaho, and sat with an Iraqi family that came through that program. I seriously doubt that family or any of the others who have benefited from that program would characterize it as a smokescreen. I don't suggest that any of our responses to these troubling and unfortunate situations are full and complete panaceas. But we're pushing various lines of effort seeking to make the overall situation better for as many people as we can. To address some of the points made about the situation in country, I noted earlier that our response here is comprehensive, and we're very much focused on ensuring that it's comprehensive. So while we're doing things like seeking to improve our domestic infrastructure for people that make it to the U.S. or running the Central American Refugee Program, we're also doubling and tripling down on our assistance within those countries. So the funds we spend and the programs we run to reform police systems, to expand access to community centers for at-risk youth, to do basic infrastructure-related things like add streetlights in neighborhoods that have been historically violent, those are things that we feel very confident are sort of bending the curve and sending us in the right direction. One of the programs we've run for years now is the CARSI program, and it's a program that's focused on community-based crime prevention. And what we found in a recent study from Vanderbilt, it seems to have borne this out, is that the programs we've run under that rubric have indeed been successful and significantly lowered rates of violence in particular neighborhoods. The only, or the sort of principal problem is that those successes have been too localized. And so that sort of leads you to our current approach, where we're seeking to scale up by orders of magnitude how we push out these types of programs. And so when you sort of work at these issues through these various lines of effort, our sort of firm belief is that we're going to bend the curve here, and we'll see a slightly more positive trajectory coming out of the region. Again, as we work with the countries in the region, as we work with NGOs like those before you, as we work with governments who have signaled to the president, to the vice president, that they do have the political will that will be necessary to work through problems that are, in all frankness, truly, truly challenging. So I'll leave it with those initial comments, but I'm sure we'll revisit. Shall I?
Thanks. My focus will be following as well up on what Jen said with respect to Mexico. And I think here, well, first let me say that UNHCR's focus operationally in Mexico has been principally on training, monitoring, working with the authorities, with COMAR, with INR, to try to reinforce the asylum structures that exist. We heard this morning that the laws are wonderful, that the system in principle should work effectively to support access to procedures and to asylum, but that in practice that's not happening. And so what we would like to see in the context of the plan and the budget that the United States is promoting in Central America and in Mexico, to the extent that on the one hand it's responsive to the request of the countries of Northern Triangle to respond to an integrated approach that deals with, we use the term root causes, which is very much a refugee kind of language anyway, that we deal with the root causes to build up governance systems, address development issues, socioeconomic issues as well. There is a humanitarian dimension. That humanitarian dimension, we hope, will translate into more sustained protection investment in Mexico. The question is, does Mexico want it? Does Mexico want it? Because maybe that would become a magnet and an attraction. And here I think that there's a dimension of refugee status recognition, of resettlement, of support, of child protection principles that need to be reinforced by the United States. We hope that there's still room for that as the budget takes shape, in order that indeed there is investment in the infrastructure for not detention but child care facilities while their claims are being adjudicated by the Mexican authorities, that there are strengthening of the NGOs locally, and that perhaps in a more traditional resettlement mode, identified refugees in whose best interest it is that they come to the United States through family reunification or just without family reunification, that there's a valve that would also give Mexico more room to reinforce its asylum mechanisms in addressing the protection needs of people from Central America. So that's also certainly something worth exploring further and debating. Thank you.
I first of all wanted to thank Ronnie for being here and kind of being put on the spotlight. I understand that your role in this panel is definitely not one that I would envy, given what all of our messages have been. But and there is a certain amount, I think, to which we have been pleasantly surprised to see that the $1 billion request from the president has really scaled back the security and militarized assistance that has been the traditional path of CARSI and has scaled up the development side of the equation. But one of the things that has been notably absent, at least in the details that have been released thus far about the $1 billion that the president is requesting, is any real emphasis on building up that humanitarian and protection infrastructure, not only in Mexico, which we think is absolutely necessary, but also in country. I have to say, when I went to Honduras for the first time several years back, what I really saw was institutions in crisis. There was inadequate or absent child welfare systems, no crime witness protection systems, few shelters for domestic violence survivors, and none that would deal with gang-based violence claims, and deeply infiltrated political institutions. I think as we heard this morning, President Obama has given his public approbation to President Peña Nieto for the work he did to manage the flow of migrants, but hasn't publicly said in any discourse that I've heard that he has expectations of Mexico that they actually vet and screen and protect people who are fleeing the kinds of violence, the not randomized violence, but the kinds of violence that we see on the ground in the Northern Triangle. And I think that he has also signaled, or at least the Vice President Biden has signaled, his approbation for the help that Honduras and Guatemala have given in also setting up border security measures on their borders, which have basically effectively locked people into their country. I was actually super surprised this summer in July when we caught wind of Operation Rescue Angel in Honduras, which is a US-funded and vetted and armed program that Honduras put into place to intercept children and families who were traveling north. And what we found from talking to child service providers on the ground who would later encounter children who were returned to San Pedro Sula, the most dangerous city in the world, was that there was no vetting by those interception units of the children for protection concerns. And that's a problem. It's the U.S. actually degrading the rule of law. It's the U.S. degrading the international rule of law in countries in which the U.S. is simultaneously trying to build up respect for the rule of law. And so I would submit that's an incoherent policy by the U.S. government.
Sure. Ronnie commented about the U.S. efforts to increase legal representation for children. And over the past year, the U.S. government has, committed both financially as well as, a lot of time really trying to work on increasing representation for unaccompanied children in the immigration process. And we definitely commend the administration for these efforts. And having been an attorney for unaccompanied kids, I definitely don't think there are enough of us. So I think it's great that they're really increasing the numbers and really working to increase the pro bono capacity as well of private attorneys to take these cases. The one thing I fear, and something that was discussed a lot this morning in terms of Mexico's process, is that we're going to get to a point where there's just kind of this veneer of due process. I mean, what we heard about this morning in terms of Mexico's problems, as well as thinking about how the U.S. is responding, is we want to have the opportunity for these people to tell their story so that we can determine who is a refugee and who is not, right? Every migration pattern is a mixed flow. You're going to have some people who are refugees, some people who are not, and we really need to allow people to have the opportunity to tell their stories so we can determine who those people are who need protection so we can figure out how to do that in the best way possible. I think this morning we heard about the ways in which Mexico is not allowing children to be able to tell their stories so we can identify them. And I think in the U.S. context, what we have to think about is, we want to make sure that kids are getting access to tell their story to a judge, that they have representation, that they have somebody there speaking on their behalf who can help them through the process. And I think, At the same time, we've tried to increase capacity to have legal representation for children. We've done a lot of things that are inhibiting the due process protections. For example, the process has been incredibly sped up through the immigration courts for children and families. So they have these rocket dockets. So there have even been instances where children have been deported because they haven't even gotten notice of their case yet. Their case happened without them, and they were ordered deported before they even had time to get to court. We're hearing that the women and children who are being held in these family detention facilities, a lot of times the courts are being held through video. So somebody has to tell their story about these traumatic experiences that happened to them over a video. People who are being screened at the borders, they're also being interviewed by agents who are going through the intake process, and that agent might be in San Diego or El Paso, Texas, and that person has been apprehended in the Rio Grande Valley. And so they're trying to tell their story and explain why they might have a credible fear and why they should have the opportunity to talk to an immigration judge, and they're doing so over a video in a room where they don't know, they're in a public setting, so they might be speaking in front of other people, maybe even somebody who had harmed them, and they don't know who's on the other end of that. So I think we need to make sure that, while we're very happy to see some progress in terms of the due process protections of this population, there's been a lot of rollbacks of these protections, and we need to monitor those very closely.
I wanted to make a comment on Shayna's last comment. Let's look at Operation Rescue Angels. What a nice humanitarian name for preventing people from fleeing their country and pushing them back to the most dangerous, San Pedro Sula, the most dangerous place in the world with no screening for protection needs. Accountability, use of proxies. I mean, I think it comes back again and again. We heard it from Francois' presentation and my question about privatization. But here we see the use of the Honduran military, police, border forces to prevent their own people from leaving their own country because a government that can't protect them from this organized violence. Looking at the Caribbean, because this is about externalization and not just about Central America, what the United States is doing with the government of Bahamas right now. Interdiction is still going on. Seaborne interdiction is still happening. And we've taken a page out of Spain, which uses Senegal and Mauritania, has basically stopped the biggest migration flow going into Europe up to 2005 was basically stopped cold because what you did was you engaged with the countries of embarkation and you provided boats to them and naval officers and surveillance, and it was their you had proxies that were preventing people from leaving. So your hands remained clean and you were unaccountable. And so the U.S. has taken this with the big search and rescue territorial waters areas of the Bahamas and done the same thing, the exact same thing that Spain was doing with Senegal and Mauritania with the Bahamas, which is now scarfing up Haitians, Cubans, whoever they can get in their nets, basically, taking them to the Carmichael Detention Center, where they don't have protection processes, where the Cuban consul comes and identifies within 72 hours the Cubans that have been interdicted. No protections whatsoever. And this is all totally bought and sold by the United States as a way of having no accountability for interdiction. We don't see it in the newspaper. We don't hear about it. We know nothing about it. And yet, so the numbers are down. We don't see Haitians landing in Miami. Isn't that great? We don't see Central Americans in Texas. Isn't that great? Out of sight, out of mind, see no evil, hear no evil, speak no evil.
One comment, and I think this harkens back to Shayna's intervention. I actually don't feel as if I am isolated on this stage. My sense is that the protection-related issues that you all care about so much, I care about fairly equally, and there are lots of people within the U.S. government that feel quite the same way. So there's a degree to which I think we're much more on the same page than this discourse might suggest. One delta or distinction, though, is that as the government, we do have to manage a range of different equities at the same time. So as we're pushing countries to improve their protection frameworks, as we're creating a range of routes for people in need of protection to get to the U.S., we also have to ensure that we do our job on other issues. So, for instance, we've talked a lot about migration and border security. And so in these mixed migration flows, in addition to vulnerable children, you also very much have human traffickers. You also very much have drug traffickers. You also very much have smuggling networks that are run by transnational criminal organizations. And it is through this smuggling that they get the funds that help them to feed back in and generate the violence and the abuses in these communities that bothers us all so much. And so as a government, we have an obligation to push as hard as we can along each and every one of those fronts. And as we work through that process, I would not suggest that we always get the balance or the calibration exactly right. And so that balancing process is also something that's an ongoing process. I mean, you see that even sort of within the protection sphere. So take, for instance, in recent years, we've shifted our resettlement program to a place where we're bringing in lots of people of Arab descent, Iraqis, and soon increasing numbers of Syrians. And so as we place these populations in various places around the country, we get schools that aren't prepared with the requisite linguistic capabilities. We get NGOs that have aided the program over the years that aren't as prepared to work with this particular population. You have Arab American NGOs that are eager to engage, but they don't know the system because they don't have the same type of history. And so as we push on one front, we realize that there are issues that we need to address and inadequacies that we need to correct on another front. But it's an ongoing process. That's why I think this conversation is so important, because all of this is fed back into our internal conversations and help us get to a better place over time. I would, on the Haiti piece, I do think this is another place where I think we do have a genuine and well-founded interest in discouraging people from taking, again, dangerous sea voyages across the Caribbean. It was only a week or so ago that I think we had another shipwreck that I think resulted in the loss of life for 20 people of Haitian descent. And so if we can discourage those sea voyages, but nevertheless put in place structures that allow people to get protection, my sense is that that is the best of both worlds, or the best way to balance the various equities that are at play. On Haiti in particular, we've recently launched a family reunification program to try to get to a number of Haitians that have been seeking to get into the U.S. for some time. Most of these people are would-be immigration beneficiaries, but as many of you guys know, there are certain limits to the number of people that can come in from particular countries in every year, and so we have this long queue that's piled up in Haiti. We've recognized that. We've heard that comment from NGOs and people in civil society, and so one of the ways we've sought to address that is by establishing this parole program that will give people an opportunity to come here immediately, and the sort of wait that they'll still need to wait in line, but they can do that here with their families as that queue works its way through. And through that program, we estimate that we'll bring roughly 5,000 people a year. But again, I think that's another sort of manifestation of our route to balanced and effective policies on these complicated issues.
I might ask you a question, Ronnie. I wondered, I was heartened to hear and certainly recognize the U.S. commitment to protection and the real policy commitment to ensuring access to humanitarian protection. And I wonder, not necessarily just in the context of the additional appropriations that are under discussion, but also in the context of existing foreign assistance authorities, whether you could address one of the concepts that we've kicked around over the course of the day is this idea of conditionality. So either using this notion of conditionality in the context of bilateral assistance to Mexico, perhaps, or just a bilateral emphasis on the goal of protection, whether there are programs that could be implemented that you think would alleviate some of the concerns about access to procedures that Shelley mentioned and that others have mentioned throughout the day, that you think are within the scope of realistic possibility within the bilateral relationship.
I think that makes a lot of sense. That's a good question. A couple of things I'll note is one, as Shelley alluded to earlier, UNHCR is a regional, initiative focused on these issues, and getting Mexico to a better place with this protection framework is part of that, and we've funded and will continue to support that as one approach. We've also done direct bilateral cooperation over the years. So, for instance, in the past, we've brought Mexican immigration officials to the United States to participate in our asylum officer training. If Mexico is going to get to a place where it has sort of a world-class protection framework, there is potentially a role for us to play in sharing what we know and what we've learned over the years. So those are things that we have done and we will continue to do. Another thing I'd note on that front is we have an active conversation with the Mexicans on these protection-related issues. We also have active conversations with them on, smuggling and trafficking-related issues and other border security issues, in addition to, trade-related issues and education-related issues and everything else under the sun, because we have a multifaceted and strong relationship with Mexico. But one thing, and this is a place where I and the others in the National Security Council play a key role, is ensuring smooth coordination across that range of issues. We have various actors at the various agencies pushing as hard as they can on their niche parochial issue, but because all of these issues have implications in other places, there's an important role to be played by people like me, making sure that the right hand knows what the left hand is doing and that we are coordinating effectively and maintaining a good, consistent, coherent message with the Mexicans and every other country that we're engaging on these issues with. And, in that regard, we have noted in the context of, border security and human smuggling and drug trafficking conversations, the need to keep protection issues top of mind. So it is not, it is a misunderstanding if people think that all of these conversations are siloed, because they're not. And, is it an ongoing process of continuing to make sure we're getting the balance right? Of course, but we're focused on it and putting in, I think, the time and the resources, and we will do more of that as the days and months and years proceed.
Ask if any of the other panelists have thoughts on this question of U.S. policies and practices, and are there specific recommendations that could be implemented to address some of these issues, and then certainly open to more discussion before going to the floor.
Well, if I may, I would just first of all like to acknowledge the support that the United States gives to UNHCR. It doesn't always go without saying, so I think it's very important to say that. And that having been said now, the kind of money that Mexico needs to transform the manner in which it operates is not, I think, hundreds of millions of dollars. It is a small amount, relatively small amount, that could have a transformational impact. But that being said, I think there is an issue of political will. But the experts who were there and who reported back this morning might have more to say about that. So the training that we undertake, and that has been undertaken also with Canada for that matter, of immigration officials doesn't address the fundamental disconnect between the reception capacity, the screening, and the policy. Sort of the underlying policy is now one of send them back. Just send them back. Let's make it as uncomfortable as possible. Let's discourage requests for asylum. Let's keep the conditions of detention bad, so that these children and their mothers, for that matter, go back to where they came from. And that is, I think, something that needs to shift. And the way ORR works, even notwithstanding our fundamental problem with Dilley, at least Dilley is comfortable. It won't. We don't like Dilley as a matter of principle, as a place where mothers and children are detained, where asylum seekers are detained. But nevertheless, the conditions, I was just there a couple of weeks ago, are remarkably comfortable. But nevertheless, it's not a good place. In Mexico, the conditions are bad, and they're only going to get worse because there isn't that investment. But the border officials are not capacitated to do screening in much the same way as CBP is really not child-friendly and in a position to do screening, and that we've established with respect to Mexican children who are seeking asylum or who may seek asylum in the United States. So I think that there is some room still for transforming the workflow, if you will, but that requires shifts in the overall purpose. The design has to, the form has to follow the function. And it's not fit for purpose. It's now fit for purpose to the extent that the purpose is to discourage people from seeking asylum in Mexico. So that's a critical statement. And I guess the appeal to the United States and to other countries, it's not just the United States that has to bear responsibility for this. This goes before the Universal Periodic Reviews. It's a matter of the human rights, basic human rights as well. UNHCR has a role to play. Canada is obviously engaged to some extent as well. We need to work with and find out what is the tipping point, or how can we help bend the curve, which is a nice phrase, so that Mexico does better in terms of implementing the laws and respecting the principles enshrined in the convention and in the Cartagena Convention. So that would be a reflection on my part.
Just speaking of UNHCR and the role that they play in the region, and the importance of having that expertise on the ground in the Americas, and UNHCR's presence in Central America, in the Western Hemisphere in general, has always been, in my opinion, as a Latin Americanist, as someone who's worked on human rights in Latin America for some time, woefully inadequate, underrepresented for the protection issues that we certainly see are in play. I believe that UNHCR put out an appeal last year, for the work that they're doing in the region. And if I understand correctly, it was 16% funded by the international donors that came to the table. I think the world, for some reason, has a blind spot where it comes to Latin America. The US has a blind spot when it comes to Central America, but at our own peril. This is a region that is now one of the most violent in the world, if not the most violent in the world. It's certainly the most violent in the world that is not a conflict zone. And unfortunately, we as a nation have vacillated between using Latin America for our own ends and neglecting a situation that is rapidly becoming a very, very much a humanitarian emergency. And I'm hoping that going forward, that we can dialogue a little bit more with the US government and with actors in the region about the importance of setting up that protection infrastructure to ensure that people do have the right to stay in their home countries. Because I think most people do want to stay in their home countries, in their home communities, if they have the ability to draw down those equities from the civil infrastructure of the state, rather than
only seeing the militarized presence of the police on the street as the one kind of knee-jerk reaction to instability and insecurity.
Just on the narrow question of the in-country processing program, two things. One is if you simply dropped the well-founded fear of persecution criteria from it and made it simply a straightforward family reunification program, it would be simpler, and you're still, the universe of people that you're capturing based on the lawfully present parent is still a very small, finite number of people to begin with, and you could have a program that doesn't purport to be protecting, that wouldn't be used as an excuse to deny others, and would actually be a benefit to those people. Or alternatively, you set up an emergency transit center, as we have seen in the Philippines and Romania, run by UNHCR in a third country, have people wait in line appropriately, parole in those who don't qualify, so that there's an assurance to the third country, Costa Rica, for example, that they won't be left with a residual population of rejected applicants, and run the program in a way that would be a safe program for people that actually have a refugee claim. So you have two alternatives, and I'd like to see whether the U.S. government would pursue either of those to give the program, as modest as it is, a little bit of legitimacy.
So one comment and perhaps a question back to you. I think we try to target our in-country program at addressing what we saw as the most prominent concern, that there were kids literally at risk of harm. Principally from gangs, and because of that, we set up the program to include a harm construct. So in order to move through the program, you need to qualify as a refugee. But recognizing that in certain ways, the refugee standard can be somewhat limited, we added a parole component onto the program. So you need not necessarily be able to satisfy one of the 5 bases under the refugee convention, but you nevertheless need to be able to demonstrate some risk of harm. We thought a program structured along those lines would be best suited to get at the problem we've discussed for the last hour or so most quickly. To the extent we made it purely a family reunification program, is there no concern that you might have certain children who are not necessarily in immediate near-term peril, squeezing out others that are more in need? I just want to understand the
program
delta there.
doesn't protect a person that's in immediate peril. I mean, you're putting them in danger by giving them a false assurance that they're going to be protected. You're telling a person that's in danger, that has a well-founded fear that a gang is going to kill them, wait around for a year to be processed. And maybe if you don't actually qualify, then maybe we'll parole you in after that.
So again, but just to reiterate the question, I still don't think I understand why converting it to a pure family reunification program would be better. How does that address the concern that you're expressing?
Because you don't purport to be protecting people and giving them false assurances that you're protecting them when in fact you're putting them in danger. This is not a program for people who are in danger. This is a program that could work as a humanitarian program to reunite children with their parents that are lawfully present in the United States. Perfectly fine, do that as a program. But don't call that a protection program, because you can't protect them there. If you want to protect them, then create an emergency transit center, take them out of danger, and protect them. Don't tell them that you're protecting them when in fact you're putting them into danger. It's immoral.
I don't think I fully understand how we would be putting them in danger, but let me just try
By
to finish.
telling them that you're protecting them and then telling them to wait around for a government that cannot protect them is the starting point. They don't have government protection. Gangs are threatening their lives. They're raping this girl. And you're telling them to come back for 4 interviews, get DNA testing. And you know what else? You have to get cultural orientation before you're allowed to come to the United States under this program. Wait around for cultural orientation while somebody's threatening your life. I mean, it's ridiculous.
So what I will say is that in the structure of our program, the children come in very early in the program and engage with the International Organization for Migration, which runs our resettlement support center in Quito and is the principal actor on the ground that engages with these children. At that point of engagement, any child or his or her caregiver has the opportunity to note some of these immediate, super time-sensitive, life-threatening concerns. It has not been our experience thus far that people have said, I need to leave tomorrow. They have come to us because their situation at home is not particularly safe. But the sort of scenario that you are painting is not one that we have heard in our engagement with children thus far. To the extent we get to a situation where we're having lots of children come in and say, I need help and I need it tomorrow, there are things that we can do. It is at least conceivable that you could set up an emergency transit center, but our parole authorities...
So why don't you do it?
It is, again, I think we'd want to see the need demonstrated before we move to take recourse like that. But our parole authorities also allow us to bring people in quickly if the need is clearly demonstrated. So again, I think we recognize that concern, and I think there's a degree to
Parole's for
which...
people who don't qualify.
Say that again?
You just gave the opposite reason for parole as stated in the program. You said if someone's in imminent danger, you're going to parole them in. In fact, parole is for people who don't qualify as meeting the standard of law found if you're being persecuted.
Our parole...
It's just the opposite of what you said.
Our parole system as structured is a backup to the refugee program. We would like ideally for children to flow through the refugee program because within that there is a path to legal status here in the U.S. There are a set of benefits that come along with entry. So that is the ideal. For children that don't qualify under the U.S. law standard for refugee status, there is a parole backup, but that would generally run on the same type of timetable. My point in response to your scenario of an immediate time-sensitive threat is that those parole mechanisms can be invoked on an immediate basis. And so that is something that we could turn to if the need presented itself. Another thing that we've tried to do is we've worked with NGOs to see if we can identify a series of shelters in the region where people can turn if they need somewhere to go on a temporary basis as we try to move as quickly as we can to move them through this program. So I guess the big picture response is we recognize the needs that you are articulating, and we think we have or are developing a couple of options that can help address those issues as they arise.
So I'm sensitive that many people here would likely like to engage our panel. And so what I'd like to do now, thank you, Andy, is to give an opportunity for people to ask questions. If you wouldn't mind, be kind to introduce yourself when you do so. If you'd like to direct your question to a particular panelist, you can. Otherwise, I'll throw them out to the group. Sure.
Hi, Clay Boggs from the Washington office on Latin America. I think you know, Ronnie, that my organization shares all of the concerns of all the civil society participants here today. And what I wanted to ask you is, you mentioned balance and getting the right balance between the different components of responding to the increased child migration from Central America. And in terms of not just programmatic balance, but also diplomatic balance, I think for us, a major concern, which Shana raised, is that both the President and Secretary Johnson have been really enthusiastic about their support for Mexico's enhanced enforcement efforts. And what we haven't seen, either coming from the White House or from the Secretary of State or from DHS, is any expression of concern expressed to the Mexican government about protection concerns, about corruption, about the widespread crimes that are committed against migrants in Mexico, from human trafficking to kidnapping to extortion. And so I guess my question is, how is the United States government communicating to the Mexican government, publicly and privately, its concerns about immigration enforcement there?
Yeah, I think you touched on it at the end of that intervention, that there are a range of ways in which we send messages to and signal to other countries. And what we try to do is figure out what approach is likely to be most effective. The Mexicans are a good partner of ours, and we are able to work constructively with them on a range of issues. And to the extent an issue comes along where we think they are perhaps not doing as well as they could be or should be, it is at times not the best approach to, go grab a microphone in front of the press and reprimand them or scold them as if, we're talking to a child of ours. And so I don't know that we should assume that what is heard publicly is the full spectrum of what is discussed and talked about privately. And there's a time and place for both. And we actively have those conversations on a day-to-day basis. The other thing is the Mexicans are party to the Refugee Convention and the protocol. They have a domestic legal framework that is in many ways very progressive. I also think there's a degree that we should have a little more confidence in the ability of the Mexicans to sort of get there over time. I don't sense that the Mexicans are a bad faith player on any of these issues. And so I'd close with that. But to your initial question, I think there are a range of ways in which we have these conversations and communicate things that we think are important with our bilateral partners around the world.
This has been amazing. This was what my mother wanted to see, and my father's. Lots of good interchange like this. There's clearly, just from being here all day with all these wonderful things, seems to be a disconnect between what I've been hearing about the immediate danger and what I hear about in my own profession, in my own academy around with therapists and social work who work with some of these populations around the dangers and the immediate dangers, along with the Mexican government not always being interested in being a good player, and what the U.S. government, when you say they're not hearing enough about this immediate danger, and I'm wondering, are the questions not being asked properly, or how come there's such a disconnect between all the immigrants who are or migrants who are talking about, and these people they've talked about? They're saying many people are in immediate danger and dying and being tortured, and they need out now. And what you're saying of, we don't hear those stories, so we haven't set those things up yet. So I just wonder where the disconnect is.
Let other people speak if they want to, but one thing just for clarification, I don't think there's any doubt within the U.S. government that there are immediate dangers in various parts of Central America. And that's why, in addition to requesting $1 billion in the FY16 budget, we aggressively moved to reallocate funds in our current budget to try to get at some of these issues immediately, so that we're on the fully same page there. I was making a more narrow point that in the context of our refugee and parole program, early in that process, there is an opportunity for the child and his or her caregiver to interact with our effective agent in that program, the International Organization for Migration. And it has not been our experience to date that people have come in, because our pre-screening interviews have commenced, that people have come in and expressed a need to move at a pace even more quickly than the pace we're trying to maintain.
I'm asking about, because I'm hearing that they are having those experiences, but in that interview process, you're not hearing that.
And it may be the case that that will change. And so I wanted to note some of the potential forms of recourse we had.
Yeah, and just to respond to your question. So as of the last statistics I have of a few weeks ago were only 167 affidavits of relationship had been filed by the lawfully present parent in the United States. The criteria of who can be eligible even to apply for this program is so narrow and so small that we're talking about I mean, we had, 68,000, kids that were apprehended at the US border last summer. 68,000. And this program, which is the first thing that Ronnie talked about, is the first thing that the US is doing in response, is of the people that even apply for it, let alone who might be eligible to go through all the hoops of DNA testing and screening. 167 affidavits of relationship filed by the parent to start the process, involving 187 children. And then we begin a screening process. We begin medical testing, DNA testing, all of that. It has to be a lawfully present. There are 6 categories of lawfully present parent, and it's based on people that arrived in 2005 with temporary protected status, whose children would already, add the 10 years to that already, and how many of their children have already aged out because of the number of people that actually qualify for this very, very, very narrow program, which is being presented as this protection mechanism. As I say, I think it's very clearly a sham. So yes, it may well be the case that the handful of people that they've pre-screened don't necessarily present an imminent danger, but then they may not qualify for the program at all, and at the end of the day, they're going to have to get paroled in, which means that they have to pay for their ticket themselves. They arrive with no benefits whatsoever. Parole is virtually nothing at the end of the day. For those who don't qualify as having a well-founded fear of being persecuted.
Very quick response. I don't want to dominate the conversation, but I think on this issue of the numbers flowing through the Central American Minor Program, I think what I would ask everyone to do is to give the program a little time. It is fully and completely natural that when we ramp up these programs, they start in the teens and in the hundreds. Programs like our Iraqi program that's, at 18, 19,000 at this point. When it started, those numbers were in the teens and in the hundreds. And so, for instance, he noted that there were 100 and so applications covering 100 and so people. I checked in with our team last week, and we're up to 340 applications covering 403 people. And the numbers are increasing at an exponential rate, and my sense is that will continue. As far as the potential universe of people, we looked into those issues before we launched the program. We realized the scale of the challenge, and I think you can rest assured that we didn't go through the trouble of setting up what is a fairly resource-intensive program if we thought that it could only reach a handful of people. There are thousands and thousands of people that fall under the 7 forms of lawful status you can have in the U.S. to access this program. So again, what I would say is to give the program a little time, and if we have this conversation in May, and we have it again in June and again in September, my strong hunch is that we'll be talking about numbers that are an order of magnitude different. Or hopefully we've changed the circumstances and the situations in Central America, and maybe we aren't. But that's your sort of 2 option set, I think.
Jen, did you have something?
Yeah, in terms of your question, kind of just looking at it more broader, a lot of our work is talking to governments and to NGOs who are interacting with these people, is thinking about who's asking the question, are you in need of protection? Is it a law enforcement agent who's wearing a gun who might have been the person that just tackled them in the desert, and then they say, are you scared? Well, yeah, I'm scared, right? But, are they going to be able to answer that question in a way that's going to trigger some sort of international protection? And then, what are the questions you're asking? So those are 2 very important things, and, really thinking about not just in the U.S. context, but, earlier we were talking about the Opis in Mexico, and so, they might wear a blue vest that says Opi on the sleeve, but what does that mean to a child who's just escaping? Do they understand that that's someone that's intended to protect them and is going to be asking them questions that they should be honest with, and tell them what they need? And so those are kind of those 2 key elements to even really parse out this migration population and see who needs protection.
If I might just really quickly intervene as well. I think that there is, and Ronnie, you said this earlier, a need to recalibrate sometimes when we understand what the cultural and historic understanding is of a refugee population that is benefiting from a U.S. program. Central America is a very interesting context for the U.S. In that there is a lot of distrust of U.S. actors in Central America because of our historic role in Central America during the 70s and 80s. And it's really difficult, I think, for Central American parents up here who may have been living here for many years to trust that the U.S. is going to be kind of a fair broker for their kids. It's really difficult, really, really difficult for civil society groups on the ground that are closest to the people who would be the kind of immediate beneficiaries of this program, especially in the context of Honduras, which has such a fractured civil society that came out of a 2009 coup, not trusting each other at all. And especially not trusting the U.S. government, because the U.S. government took a long time to acknowledge that a coup had happened, because we didn't wish to cut off military aid, which would have been the fallout of acknowledging that the U.S. that Honduras had a coup. We did finally acknowledge that, but in many ways it was too little, too late for some of the NGOs who are kind of who play that role closest to the people and who might be most able to identify children who are in need of protection. And so I would just put that out there as something that the U.S. might explore as they go forward.
I think that's a very helpful comment, and I think that's one place where we are eager to receive as much input as you guys are willing to provide. One thing that state and DHS have been doing recently is these outreach calls to NGOs and civil society actors seeking to get as much assistance as we can in spreading the word that this program exists and that it is an opportunity to get at some of these children at risk. And we've also tried to do a fair amount of Spanish language media, which we hope will help us in increasing awareness. You know, one thing that's unique about this particular program is you have people that are here under a wide range of statuses, and people that have previously had no prior relationship with the sort of refugee infrastructure. So there's a need to sort of inform them and educate them about that first, and then explain to them the particulars of this program, and then encourage them to get their applications in. And that is a process, and we're in a better place, you know, now than we were in December, and the hope is that we'll only, you know, continue to build momentum.
I'm having a language problem and a challenge, especially after our wonderful keynote speaker at lunch. Migration is not a crime. Why is it called parole? I can't find any definition that doesn't involve someone who's been convicted of something or a criminal. And every time I hear the word parole, I'm thinking paroled from what? From applying for to be accepted? So that was number one. Number two, what Bill said about dropping the imminent danger. If you live in a country, I mean, first of all, poverty, extreme poverty and living in a dangerous place could really be an inherently really dangerous, perilous thing. You could get killed tomorrow or not. And if there's a family member especially, they're already, how do you know imminent danger from tomorrow danger or danger next week? I mean, they have a family member to go to and their children. I'm not really clear why the proof of imminent threat, it sounds like it might slow things down. And the idea is to get them children out of a dangerous spot. But first I want to know why you call it parole.
Okay. Very good question. It is the same term, but it is completely unrelated. It is simply an authority that exists under the Immigration and Nationality Act. It allows the Department of Homeland Security to bring in any foreign national without that foreign national needing to be lawfully admitted. It is authority that's used in lots of ways. You could imagine a Senegalese individual who needs some emergency health treatment that's only offered at a hospital up in Boston. Having that person go to the embassy and apply for a visa and run through that process might not be the best way to get that person the health care they need. And so we have an authority under the Immigration and Nationality Act to effectively, subject to DHS's secretary's discretion, bring anyone into the United States. So that is the immigration definition of parole, which is completely. We will talk to our friends up on the Hill and see if we can change the terminology there. So on that, the only other point I'll make is there is no need to demonstrate what you refer to as imminent harm to move through either one of these programs. I guess the point I attempted to make to Bill is that the way the program has been structured, we are looking for some indicia of harm. There needs to be some situation that presents a threat or a risk to the child in question, and that is the way we've sought to allocate, the slots in this program in those three countries.
It's very important that that the CAM, which UNHCR supports and has supported since its inception.
The Central American Minor Program.
The Central American Minor Program should not, to borrow the term, externalize asylum. And so it's critically important that while a lot of attention has been focused on it as a program, that access to procedures, access to territory, access to counsel, access to care, access to family, if they've got it, should all be guaranteed, as it has been up until now, for minors coming from Central America at least, that all continues in the best of American traditions. To see a change in statute that would treat the children from the Northern Triangle as children from a contiguous country, which has been an issue on the congressional agenda, is preoccupying, I think, not just for UNHCR, but for others here and in the audience. And so we would encourage, of course, everybody who cares about protecting these children to seriously consider any such change as not in the right direction. But anyway, I just wanted to make that point that the focus should be on asylum in the United States, or for that matter, in Mexico or Costa Rica, or wherever the children and their mothers and fathers present themselves for protection.
I would just like to thank you to begin with for being willing to listen to all of the comments that have been made by the panel, particularly because I haven't been always convinced that our government was actually listening to us. And so I think that today we've heard some really very good information, which I gather you'll take back and chew on. But secondly, you spoke a number of times about a wide range of programs. If you had to select two as your most effective programs that would do the most good for the most children in the next year, what two programs would you put your money on?
Programs that we've pursued in the Central American region.
Yes.
I mean, I think
for the unaccompanied minors.
For the unaccompanied minors. I mean, I think since you gave me two, I do sort of both sides of the coin. I think ultimately we want to create a situation in which people in need of protection and people that need to flee can access it. But we also want to create a situation in which conditions at home are safe enough that people can live and pursue life, liberty, and happiness just like people can in other parts of the world. And so I think our Central American Regional Security Initiative, CARSI programs, have proven to be effective. And as I noted earlier, the key is to build those out and to expand them. What we have now is these isolated islands in various parts of these countries where we've started to see progress. But we have pretty wide-ranging problems stretching across large swaths of these countries. And so building those programs out efficiently and effectively is key. And so we need resources on our end. We need continued and increased commitment for the governments, from the governments down there. We also need our NGO and civil society partners. So I'd note that. I'd also note that, through a range of NGOs unrelated to the sort of most recent crisis, we've long worked to build up protection frameworks. So if it's working with HIAS in Venezuela to help out Colombian refugees, or working with Asylum Access in Panama, again, to build up their sort of protection framework so refugees can not only remain, in country, but also access rights to work, rights to education, the whole spectrum of rights that are outlined and enshrined in the Refugee Convention. That ongoing, deliberate, continuous process of building up the protection frameworks, not only here, but throughout the Americas, is where we're focused and what we prioritize. And so that'd be the second piece.
But if you have these 68,000 children, what's immediately helping the 68,000 unaccompanied minors who came to the border in the last 14 months?
Well, for the vast majority of those children, the sort of structure that we've set up that involves HHS has stepped into that role and allowed them to be placed with sponsors, in many cases family members around the U.S. And so the vast majority of these children are placed in homes and enrolled in schools, as part of the conversation we were having earlier, where we've needed to in turn make sure we were supplementing and supporting these school districts that have seen large influxes that they weren't necessarily prepared for. And so I think I agree with Shelley wholeheartedly that maintaining that sort of basic structure is essential, but then making sure it runs as smoothly and efficiently as it can. So last summer, when we got more numbers than we were really ready for, frankly, we ended up with transition times between CBP and HHS that were frankly too long. We've gone a long way to working through that. We ended up with children at HHS in that period before they get placed with a sponsor for a little bit too long. We've worked to build out that capacity, and I think we're in a much better place today than we were, 12 months ago. And so I think that perhaps is more responsive to your question. No problem.
Hopefully, many of the panelists can weigh in on what I'm sure will be another answerless question from today. I wanted to turn attention back, not to the in-country processing prong, but to the other prong, which is the $1 billion in aid that is now going to the Central American countries. Historically, giving lots of money to what are basically failed states with rampant corruption and infiltration by organized crime has not yielded a whole lot of positive results for the goals that policy is seeking to attain. So I'm trying to get at sort of what measures are being taken to ensure that money is actually used to strengthen the rule of law, and maybe if some of the other panelists could weigh in, how do you all see sort of the use of aid in strengthening societies to get at some of these issues that are really creating an unsustainable environment for the populations of these countries?
I can perhaps start. So one thing that's essential in making sure that this money is spent wisely and that we actually do see changes on the ground is conveying in no certain terms how serious we are about these issues and how important they are. And on that front, I think you have seen that the President of the United States, the VP on a number of occasions, have directly engaged with governments in the region and leaders in the region to let them know that we are, all in to the extent they are also all in. So conveying the importance at very, very senior levels is part of the answer. Also, there's been an increased commitment to ensuring that they are doing what they need to do themselves. And that has come from the executive branch. Frankly, that has also come from Congress. So getting the true political signals that these leaders are willing to do what it takes in country, which might cause them, periodic political problems, which, might require that they clean up, police departments and departments of justice that have grown a bit corrupt or at best case ineffective. And in that process, you're likely to have some tension and some friction. But ensuring that we have that top level commitment to push down through the system in a way that's likely to make these programs stick and to actually result in some positive benefit, we spend a lot of time there. We also try to aggressively and actively monitor what we do. So I mentioned earlier the Vanderbilt study on the CARSI programs to date. Whenever there are these third parties that come in and evaluate our programs, we read those assessments and evaluations closely. We find out what things we think have really worked and what things perhaps did not, and we adjust and recalibrate on the basis of that. The other thing I'd note is that these programs typically don't work. These programs are typically not, here is a check from the United States, and you hand it over to the leader in the country. These programs are operated through a range of actors, contractors, NGOs, civil societies that are there and are on the ground. And having those true on-the-ground tentacles is part of what allows us to feel confident that we're actually, meaningfully making a difference here. So those are a handful of things I'd highlight. But I'm also open to hearing the thoughts from others on the panel about things we can do to make sure that we actually, change the trajectory here. Bill?
Yeah, I think it's a great question and one that we've certainly at Human Rights Watch thought a great deal about. I think, we're fully supportive of addressing the causes of human rights violations, the causes of economic deprivation. Well-managed, well-evaluated, programs of rule of law development as well as economic development are all to the good. But I think the major concern that we have is that, when you're looking at root causes, you're digging into the root. And that is a long, hard, slow process. And it's not going to have immediate benefits. And when the measure becomes stemming, what's the title of your report? Stemming the tide, stemming the flow, and the measurement and what you see from declarations of government authorities is, we see great progress because these numbers aren't appearing at our border anymore, so congratulations. When the measure is stopping a migration flow, it's easier and cheaper to stop the consequence of these root causes than it is to address the root causes themselves. And so when you talk about these notions like preventive protection, the fear that we have in declaring the right to remain, these kinds of rights that are pulled out of thin air, is that what you're going to do is, instead of putting those resources into actually addressing these root causes, is you put them into the proximate issue, which is the migration flow itself, and you stop the flow with an Operation Rescue Angels or whatever it might be, and you chalk that up to success, because it is a whole lot easier to just pay the enforcement people to stop the flow, build fences, put in those barriers, than it is to truly address root causes that are going to take decades to achieve.
In Central America's Northern Triangle, I think what we've seen as one of the most persistent factors that has led to such instability and lack of institutionality is a weak, a decimated civil society. And that's a civil society that has come out of the civil conflicts in the 1980s and the 1990s, barely had the opportunity to recover from that period of open conflict before they were launched into the middle of what is really transnational organized crime taking over to a certain extent
apparatus of the state. I think then that the solution really does come down to making sure that we do partner, and I would say probably through multilateral actors, since there is that trust deficit that I talked about before, that we partner with civil society in countries, in El Salvador, in Guatemala, in Honduras, who are able to then build the capacity to hold their governments accountable for democracy, for good governance, for fair use of revenues. And I'm hoping that the U.S. government, as it moves forward, if Congress sees that this billion-dollar investment is in fact a good investment, that the U.S. government will move forward with that governance and prosperity prong of the GPS plan that they've that the $1 billion is supposed to be supporting, and that really where we concentrate our investment, where we concentrate our money, is in building a civil society sector that can hold governments who we've seen over time have not been good or trustworthy actors accountable. I also think that small and medium-sized businesses are places that we should invest. We see this region as having real vast amounts of inequality, one of the most unequal parts of the world. And to a certain extent, violence is fed by the inequality, and inequality feeds the violence. As people are extorted out of business, especially small business owners, that leads to more inequality, it leads to more poverty, and poverty has been seen over time to be a significant driver of violence. So I'm hoping that we choose some of those non-traditional actors going forward, rather than continuing kind of the same old playbook of measuring our success through how many drugs were interdicted, rather than how people really feel the security situation is on the ground.
I could not agree more with that comment, and I think that is a big plank of what has been the president's focus. Many of you are probably familiar with the Stand with Civil Society initiative he launched at UNGA a couple of years back. I think there is a recognition on his part and a recognition on all of our parts that in order to see change on these deeply rooted problems, you need civil society to grow. There are only so many trips to the country and only so many talking points you can deliver and only so much value that isolated moment can have. What you need on the ground is a vibrant and empowered civil society that can push these issues. And so we've also stressed that at every opportunity. You saw that this past weekend down in Panama, where in the context of the Summit of the Americas, there was a civil society forum, and we're working to get that component institutionalized. So every time we do one of these summits, we're bringing civil society from around the region to the summit to engage with leaders on these issues. So again, I could not agree more. I think the sort of business and small business and economic empowerment piece is really important. You know, one of the programs we were talking about recently is a USAID program, which works with educational institutions in the region to provide technical training to disadvantaged youth on market relevant skills. So not only educating them, but educating them to do things that they can, effectively monetize. And those opportunities will give them, a plan B, which gets them away from joining the gang, which for far too many of them has ended up being the only option. So that'd be the second thing I'd point to. And this emphasis on civil society is an emphasis because it's borne out in our experience. Part of what we think makes America a strong country is that we do have such a robust and empowered civil society, and it is through engagement with that civil society that we work towards getting the right answer. Like you made the point earlier about being pleased that it appeared as if we were listening. So for instance, we very well may have come up with the in-country Central American minor program on our own, but it is also the case that last summer when we started having meetings like this with civil society, several people sitting in the audience, just like you, said, how about you launch an in-country program in Guatemala, in Honduras, in El Salvador? We took that back, discussed it internally, and then put it in place. It is through that back and forth with civil society that we think we can become and continue to be a sort of government that can effectively and productively work through these challenges. And that is a big key to Central America getting to the same place.
On that note of engagement, let me ask you to help me thank all of our panelists for engagement.
So if you would all just stay up here for another couple minutes, I'll make some concluding remarks, and then we're going to enjoy a reception. An extraordinary day from my point of view. I'm a lifetime learner. I just love to be at places where I'm learning a lot, and all I can say is the launch of the fact-finding report this morning for us, the launch here, was exceptional. You've done extraordinary research. You presented your findings in a very clear and convincing fashion, and I think people heard exactly what the gap that you filled, the knowledge gap that you filled. And for me, this is particularly meaningful because you are the next generation of human rights practitioners that we want to see out in the world. And it's even more extraordinary when some of them who did what you did this year are up on this particular panel today. And in fact, we have both Shana, who had done this in the first year of the Human Rights Institute fact-finding mission to Ecuador regarding Colombian refugees, and we have Ian, who did this when he was here as well with regards to Iraqi refugees, right? Yes, some issues don't change, huh? That said, so it's wonderful to see the results of your research. We're delighted as well that we had François Crépeau, Professor Crépeau, who is the UN Special Rapporteur on the Human Rights of Migrants, deliver an extraordinary keynote address, reminding us that we have a long history in mobility, and we can do a lot better than we're doing today in terms of trying to return to that narrative that will enable us to respect the dignity and human rights of all people, including international migrants. And finally, we had this exceptional panel of experts who sparred nicely, as we like to see them spar, who had to handle really difficult questions. And that's the purpose of our program here. And I know that Sam would be wonderfully proud to see that Georgetown is the place where these questions are being asked and we're trying to get to the answers. Clearly, we need a great more transparency in the Mexican government, let alone the failing states that the United States is working with in Central America. And of course, in our own government, which is why Ronnie's invited civil society to engage as robustly as he has. And that is one of the, you should realize that when you go around the world, one of the aspects that distinguishes our society from many others, including global North countries, is that our civil society is expected by our government to play a very robust role, just in the way it took place today. So I want to thank again Ian and Becca for organizing this conference, and I'm delighted that Judy and Rachel could be here again. Madeline, thank you so much for your participation. I invite you all now to just a round of applause for everybody, and please enjoy the reception and stay for a while.
You've just been instrumentalized.
Ready for a drink?
Bill, how you doing?
Good to see you. So now you have to finish explaining it.